Good afternoon and welcome back to the South Carolina Public Service Commission. We are here in continuing the hearing on Duke Energy's IRP plan. We are now at a point where it's redirect testimony, and we'll turn it over to the Duke attorney over there.
Thank you, Mr. Chairman. Good afternoon, gentlemen.
Afternoon.
A lot of testimony over the last day and a half, so we do have a few redirect questions. Mr. Snyder, I'm going to start with you, and then I have just one for Mr. Stillman to make sure he's involved, since he's been waiting patiently for you to give a lot of good answers, and then one or two for Mr. Quinto as well. So start with a couple of questions from the commissioners that they've had today. Commissioner C. Williams had some questions for you on whether this commission or the North Carolina Utilities Commission is required to issue its order and provide guidance on the 2023 resource plan first. Do you recall that question?
I do.
And are you aware or subject to check that this commission has to issue an order by the end of November?
That sounds
26th,
that sounds right.
Okay. And are you aware or would you accept, subject to check, that the North Carolina Commission has to issue an order by the end of this year, so by December 31st, under North Carolina statute NCGS 62-110.9?
That sounds correct.
Thank you. Commissioner C. Williams also had some questions about the timing of the next IRP update and next comprehensive IRP to be filed with this commission. Do you recall that?
I do.
And there was some discussion of a potential late filed exhibit, and I think the direction was to generally engage with ORS and the parties and to evaluate a reasonable plan for that. Is that your recollection?
I do.
And you mentioned in your answer that it might be 26 or it might be 2027, but just to confirm, the 3-year cadence under the IRP statute requires the next IRP to be filed no later than 2026. Would you agree with that?
Yes.
And would you also agree that it would be an appropriate area of inquiry for the commission to ask Ms. Smith about the timing of the next IRP and the company's plans, and subject to further engagement with ORS and other parties?
Yeah, I think that would be an appropriate witness.
Thank you. And Commissioner C. Williams also asked you some questions about how best to assess the benefits of the dual state system to South Carolina and potential costs of separating South Carolina and North Carolina operations. Do you recall that?
I do.
And I don't know if you had anything to add there, but is that a topic that Ms. Smith and Ms. Bateman would also be able to address in more detail in their testimony?
Yes, for sure.
Okay, thank you. I want to turn now to some questions that you got from Commissioner Caston and Commissioner Williams about the range of portfolios options presented in the resource plan. I think Mr. Quinto established that the company's filed 53 portfolios across all the various initial plan, the supplemental planning analysis, and the Clean Air Act sensitivity that was filed. And the ORS on Friday had Mr. Quinto walk through his rebuttal exhibit, Clean Air Act 111 sensitivity analysis. Do you recall that?
I do.
Okay. And Mr. Quinto commented on Friday, and I think he said again today, that PVRR, present value revenue requirement, is a key metric in assessing portfolios. You recall that?
I do recall that.
And in the discussion with ORS on Friday, the council had him walk through his table 6, which was in his exhibit 1, rebuttal exhibit 1, page 14. Put it up on the screen here. And so council had Mr. Quinto walk through this exhibit, and I think this was the genesis of the porridge analogy we've been using so commonly about too hot, too cold, or just right in terms of the relative cost of the various portfolios. Do you recall that?
I do recall this.
Okay. And I think the line of discussion really seemed to focus on the PVR differences between the company's recommended portfolio, P3 fall base, and then the 2037 Clean Air Act and 2038 Clean Air Act portfolios, which are identified on this exhibit. Is that your recollection?
I remember that discussion.
All right, thank you. Mr. Chairman, at this time, I'd like to enter a hearing exhibit that I think will help simplify this discussion. So, Mr. Wellborn, if you'd assist me, please.
This CAA final rule sensitivity analysis is marked for identification and placed in the record as exhibit number 32.
Thank you, sir. So, Mr. Snyder and Mr. Quinto as well, since this comes from your rebuttal exhibit 1, but what what is represented here, if you look at the sources on the bottom left, is a compilation of the analysis presented in your rebuttal exhibit 1, Clean Air Act rule table SA3, which are the resource additions and retirements across these portfolios, and then pulling from your table SA6 that you walked through on Friday, which presents the comparison of PVRRs, or present value revenue requirements, across the various cases, P3 fall base, the P3 Clean Air Act Rule 2037 base, and then the 2038 base, no offshore wind. You see that there?
Yes.
And are you generally familiar with the analysis presented here?
Yes.
Okay. And just for comparison purposes, would you agree that across all of the technologies that have been identified across these portfolios, the resource needs for solar, onshore wind, nuclear, offshore wind, combined cycles, or excuse me, not offshore wind, but combined cycles, combustion turbines and batteries, and pump storage hydro are generally the same?
Yes, generally.
Minor differences across the 15-year planning horizon, but the big difference here is the amount of offshore wind across the portfolios. Is that your understanding?
That is my
And
understanding.
you had a conversation with the commission about that this morning. And then the other difference, as ORS Council pointed out on Friday, is the difference in the PVRRs between the three portfolios, with the 2038 no offshore wind portfolio being the lowest cost of those three portfolios.
Yeah, that is correct. You lose the diversification of the offshore wind, but you also do not include the cost of the offshore wind in the PVRR, and it results in a slightly lower PVRR.
Thank you. So based on this, and you kind of jumped to the head of my next question, but recognizing that the P3 fall base, which is the company's recommended portfolio, is higher cost than these other two portfolios, could you articulate for the commission why the company believes it's the most reasonable and prudent plan, and why it's appropriate for the commission to select at this time?
Yes, we had some discussion towards the just before lunch about diversification. There often can be a cost across base assumptions. So part of the reason you diversify is to hedge yourself against non-base assumptions. But under base assumptions in gas availability and all the other prices that go into this, under base assumptions, you see a slight savings in your present value of revenue requirements when you exclude offshore wind through the portfolio. And so offshore wind is capital intensive, and its benefits can extend well beyond. Obviously, it's just going into service in 33, 34, 35 in the plan. Your PVRR is through 2038. So you have a 30-year asset that will provide benefits well beyond this time horizon, and will help with the balancing factors. And so we have recommended P3 fall base over the 2038 no offshore wind as as a resource that will help with the other balancing factors in the South Carolina IRP statute beyond just strict 15-year cost metric.
Thank you, Mr. Snyder. Turning now to coal retirements, there's a number of discussions, one with Commissioner Jay Williams or Vice Chair Jay Williams this morning, specifically about whether North Carolina law was driving coal retirements, and you highlighted there's a number of significant factors contributing to the company's plans and schedule to retire the coal fleet, and I think you phrased it as the devolving coal industry and the changing operation of units over time. Does anyone recall that?
I do.
And just would like to give you a chance as part of that answer to comment on something that I presented to witness Davis for CCBA the other day, which was this hearing examination exhibit 20, which compared the South Carolina depreciation studies approved in the most recent rate cases to the company's P3 fall base supported retirement schedule for coal units. Are you familiar with this exhibit?
I am.
And you can see the column there, South Carolina depreciation study, coal retirement dates approved by this commission, and then the P3 fall base retirement schedule. Do you see that comparison?
I do.
Okay. And do you have any commentary on the relationship between those two data points?
Yes. I think what I was trying to articulate with the discussion with the vice chair is that these coal retirements, you'll notice, are spread out over time. They can't get bunched into one period because they require replacement resources. So when you bunch coal retirements together, you're simultaneously then bunching, if you will, technical term there, grouping them very close in time. Then you need the replacement resources all to come online as well. So you're creating a construction and development bundle that could be difficult in execution space because of limits on supply chain, on labor, on project management, on, you name it, when you try and build several major projects in a very tight time proximity. Also, what I was trying to show is that these dates in this IRP are not out of alignment. There's some small differences and, that as we evolve through time, for example, the Roxborough difference as we went through there, as the plant went through and looked at in very detailed what makes the most sense with like equipment and material conditions of the plant, they determined that rather than retiring units 1 and 2 together and then 3 and 4, that 1 and 4 made more sense for retirement. So you see a small difference there where our new retirement date is 2029 for Roxborough 1 and 4, whereas in the depreciation, it had a slightly different date. It had 29 for 1 and 2 and actually 28. So for 3 and 4, the time it would take to develop new resources, the growing load, those actually were shifted out, not accelerated from the depreciation study to allow for not only time for replacement resources, but with the higher reserve margin and the growing load relative to what was in place at the time of the rate case, that allows a better fit for the portfolio to meet load, meet reserve margin, and still be part of an orderly transition where you're not grouping too many retirements together and you're not pushing the units out so far to where the devolving nature of the coal retirement sort of puts those at risk of some of the staffing issues we talked about, or the coal supply issues that we talked about, or the transportation issues, et cetera. So it's really looking at this as what does that orderly transition look like, and do these units as they're sequenced to retire fall within that orderly transition as as bore out in our Appendix F and our detailed coal retirement analysis. So that really was just trying to show that these coal retirements are not some form of acceleration that's happened recently or due to any law in North Carolina, but rather are consistent with an industry trend that we've been communicating in prior IRPs and prior rate case and depreciation studies with this commission for a number of years.
Thank you. I want to turn now to a few other questions from Vice Chair Jay Williams about the cost implications of dual state planning and the specifically referencing P0. And you also had some discussions with Commissioner Caston about the relative cost of the resources that were selected in P0. Do you recall that?
I do.
But to be clear, there's no interveners in this case that have recommended P0 be selected as the most reasonable and prudent plan.
No.
And the ORS's consultant is also not recommending P0 in this proceeding, has said earlier in the case that it's not appropriate, and his testimony identifies it's not sufficiently adjusted for carbon emission reduction risks. Is that fair?
That is fair.
And similarly, the company's testimony of, I think you mentioned earlier, Mr. Verderame and Lee Mitchell, but also witness Donashad, explained that P0 introduces reliability risks due to the unreasonably aggressive and non-diverse amount of new gas generation required in that resource plan.
Yeah, I heard their testimony and agree with it.
And so it would require 6 combined cycles and 13 combustion turbines to be constructed by 2038.
Yes.
And 5 of those combustion turbines would be required in the next few years by 2029.
Yes.
Okay. And so it's, I think witness Donashad suggested that from his role and responsibility of constructing that generation, it wasn't an executable plan. Agree with that?
I do agree with that.
Okay. And so is it a fair comparison then to look at the bill impacts and the PVRR assumptions for P0 and put it on an apples-to-apples basis with P3 or the other portfolios which the companies believe are executable, since it's not a plan that could actually be implemented in the real world?
Yes, I would say that non-executability is witness Donashad's testimony, as he's responsible for execution. And then I was also emphasizing the fact that you're really introducing a bunch of risks that do not appropriately balance the considerations that we were trying to address with the South Carolina IRP statute. So on both of those fronts, we thought that would not be a fair comparison.
Thank you. Turning to you, Mr. Stillman, on Friday, counsel for CCL et al. Had some questions about the potential of projects backing out, I think was the term used, or not coming to fruition as part of the significant economic development growth the companies have experienced. Do you recall that discussion?
I do.
And you referred generally to figure 1 of your rebuttal testimony. You recall that? I put it on the screen here.
Yes, I do.
Okay. And would you just spend a minute or two highlighting for the commission what the 3 lines, the 2 dotted lines at the top and then the bold line represent, please?
Yes. So let's start with the dashed line that's titled the SPA Economic Development Load at 100%. So this is the load that's communicated to the forecasting team from the economic development team and the large account management team of what the total expectations of load are for the portfolio of 35 companies that we had in the SPA. So this is the work between the economic development company that's being talked to and our economic development team. So they're working out what the timing of that load is, and then they're passing it to us in terms of, and this is what I call full load. So that includes no discount at this point. It's what is fully expected by the company that's coming to the territory and the economic development team or the large account management team. From that dashed line, I want to go down actually to the solid line next. That's the level of sales or megawatts that we put into the forecast. So this was the discounted amount. So we went through an exercise based on history, based on our understanding of how that load may come in, to reduce double counting, because our econometric models already pick up some amount of growth, and recognizing that there's going to be some project delays and some project turnover. So the difference between the dashed line and the solid line is what goes in the forecast. The dashed line is what's being told to us what to expect in terms of full load. So now fast forward, that was in the supplemental planning analysis that got filed in January. Work was done in November and December to come up with that. Fast forward to the dotted line, the middle one. This is the level of full load that's being communicated to us again through the conversations of the economic development team and the large account management team, in conversations with those companies that are expanding and coming to the territory. So the takeaway here is really to compare the dashed line, which was the original estimate back in January, to the dotted line, which is the estimate now in terms of full load. And you can see that even though some projects have moved in and out, some delays have occurred, new projects have come in, the portfolio in total, at least in the first 4 or 5 years, looks very close to what we expected when we put the original forecast together. And then from about 2029 out, it's actually a little bit higher.
Thank you. That's very helpful. And just recognizing that the solid bolded line is below the both the initial dotted line or dashed line that was included in the supplemental planning analysis and the most current dotted line that you have there that represents the update in June. It's fair to say the company's taken a conservative approach to incorporating the economic development load that is coming to the Carolinas into the load forecast that's used to develop the resource plan.
I think that's very fair to say, yes.
Okay, and is it also accurate that the company is developing tools like letter agreements and electric service agreements that are designed to ensure new customers coming to the Carolinas are making binding commitments and would reimburse the companies if the load doesn't show up as they've made representations and initial commitments in their plans?
Yes, that process has been in place for a long time. There are letter agreements and there are electric service agreements that show the intent of the customer. It essentially gives them, or it gives us, a confidence of their commitment in coming to the territory. And I can say with looking at both of those lines, both what was in the SPA, and I believe it's still in the same ballpark for what we submitted in June with this update, about 75% of the amount of load that we've included in the forecast has one of those type of commitments.
Thank you. And you've committed to the ORS in response to one of their recommendations to provide periodic reporting in future IRP updates to address any changes to this load forecast that occur in the future.
That is correct.
Okay. And Mr. Snyder, just want to allow you to have a chance to comment on this briefly in response to some of the questions from the commission this morning where you used the phrase ahead of plan. You recall that discussion?
I do.
And just recognizing that the bolded solid line is below what the company's current best estimate of the actual load customers are representing they're going to bring to the Carolinas. Can you speak to the importance of executing on the near-term actions to maintain your ahead-of-plan approach as you discussed earlier?
Yeah, I think that's what we're trying to have the discussion around. There's different approaches used around the country. And, you know, because we use a 50-50, as Mr. Stillman explains, really developing the resources in the plan are essential to enable the growth that we're projecting at that 50-50 level. And that, as I said, falling behind plan at best will slow growth in the state, and at worst will introduce systemic reliability issues. Being ahead of plan so that you can serve the 50-50 load and potentially higher if that load grows or if their development activity happens at a level faster than we're sitting here today. It enables that, and you're able to serve that load and that load growth more readily from a position of having those resources in place relative to being behind plan where you would have to slow down that. And as I'll just end, I said this a couple times earlier, so I won't belabor it, but these companies are watching. I've never seen such a thing. I've probably been asked to meet with more economic development large load customers in the last year than I have in the last 10 combined. So they are very serious. They are hiring people out of utilities and out of private industry to form their own little energy groups within these large development customers. And they are very much tracking whether the utility is just saying they can serve their load or whether they have plans in place and regulator agreement in place to be able to actually build the resources to serve it. And so, like I said, this is something, I mean, I used to meet with these once every year or two. Now I probably get a couple requests a month to talk to different large economic development customers about our plans and where we stand in our resource planning process. So I think this is really important to be ahead of plan.
Thank you. Mr. Quinto, on Friday, you had a series of questions from ORS Council about the benchmarking recommendation by ORS Witness Welborn. Do you recall that?
Yes, I do.
And one of the arguments that the company made, or your testimony, was that it was unduly burdensome to undertake that benchmarking. Is it fair to say it's rare for a utility as large and sophisticated as Duke to suggest a recommendation such as this is unduly burdensome? This is a pretty unique circumstance. You're highlighting this as a material concern and pushing back on it.
Yes, I am. The companies have worked with stakeholders to help provide the analysis that's needed in IRP. We engaged through multiple months of stakeholder engagement prior to developing the plan, getting stakeholder engagement on the front end. And then on the back end, after filing, engaging with interveners and the ORS on discovery requests and do all that and understand it's part of the process. This is yet another layer of modeling that I truly don't believe is going to yield the results that the ORS recommends. And on top of that, the complexity of it with the size of our system is really a process into itself that's of large scale in my experience.
Thank you. And the company produces all of its modeling files and data that ORS would need to assess the reasonableness of future modeling assumptions and inputs as part of future IRP filings?
It does.
All right. And when you were addressing these questions on Friday, Mr. Snyder made the comment that IRP planning is weather normalized while real world operations is not. Can you just make sure that point is clear for the commission and explain what was meant there, either yourself, Mr. Quinto, or Mr. Snyder?
Yeah, I'll start. So the comment on a weather normal load. So we heard Mr. Pasty on direct testimony with myself talk about weather normal load forecast. So this takes a look back at how I believe it's the last 30 years of NOAA data, NOAA. I can't remember what that stands for, but 30 years of weather data and understands, what's the average temperature, heating and cooling degree days. So when we talk about a weather normal load forecast, to the extent that weather may be hotter or colder and drive more electrical use or less electrical use, can change the consumption and overall the amount of energy that's used and how the units on the system are needed to do that. So comparing a weather normal load forecast compared to an actual load forecast with doing a benchmark study like this, you can drive differences just on whether the benchmark year you're looking at was above weather normal or below weather normal.
Thank you. And at a minimum, would you say it would be reasonable for, if the commission was inclined to explore this proposal further, to direct the companies to engage with ORS's consultant in advance of the next IRP proceeding to get on the same page and ensure that any benchmarking that is contemplated is not unduly burdensome and provides value to the process?
Yes, I think that would be a good alternative.
Thank you. That's all I have. I appreciate it.
Thank you, sir. As far as Recross Sierra Club, CC, say CCL.
Thank you, Chair Bowers. And this should be really brief. Mr. Snyder, the whole panel really was asked about where you were asked questions about the timing of coal retirements in the company's IRP, as well as the timing and amount of various resource additions. Do you recall that?
I do.
Okay. You would agree, wouldn't you, that the company's Encompass modeling looks at the firm capacity contribution of these different resource options when deciding both which resource and how much of a particular resource to select?
Yes.
Okay, thank you. Mr. Snyder, I believe on Friday you said that the company's modeling included the actual forced outage rates of the company's coal and gas units. Do you recall that?
Yes.
I want to make sure it's very clear. The forced outage rate, that's a different modeling input than the firm capacity in the company's Encompass modeling. Is that correct?
I think what we're mixing up is in production costs when we run actual 8,760 hours, what resources are available to serve load, and it economically commits and dispatches resources to serve the load. The units are forced out based on their historic outage rate capabilities. It is the actual forced outage rates from history that in production cost is used. When calculating a reserve margin, the full capacity of fossil resources are included in the reserve margin calculation at the system optimization point. And so Encompass and system optimization does use the full capacity in the calculation of a reserve margin. It uses the full forced outage rate when it's dispatching. And
okay, thank you. So to be clear, in the company's capacity expansion modeling, which is where new resources are either added or retired to the system, the company's coal and gas units were modeled at 100% firm capacity contribution. Isn't that correct?
Subject to the 4% adjustment that we talked about earlier. When you do the ELCC study, the effective load carrying capability, and the LOLE, LOLH studies, that they are accounting for the fact that new fossil also is not perfect. And so when you're taking the equivalency for any other resource, if it is 96% available, it's the same rating as the fossil unit. So,
okay. And so you would agree, wouldn't you, that effectively makes the company's modeled firm capacity for new thermal units or for its thermal units at 96%?
Yes.
Okay. And so the model, when it's looking at how to add or remove resources over time, including the coal and the gas units, it's looking at its thermal units as if they are resources that can contribute 96% of their nameplate capacity. Is that right?
For the calculation of a reserve margin, one of the things that I know it gets really in the weeds and we're getting late in the day, but we also do the verification step. So the very last thing we do in the whole modeling process is to say, this portfolio we came up with, let's put it back through a stochastic model to see if it still meets the 1 day in 10, because ELCCs are point estimates based on a portfolio at a point in time. The portfolios are all different. So we have to say, is that value still valid? Let's do one last validation step. when we do that validation step to say, does this portfolio meet the 1 day and 10-year standard, which is a process that came out of this recommendations from the 2020, which is to enhance our reliability modeling. And this was added as a result of that from this commission. That still looks at, that validation step takes the actual outages of the unit and puts those into that validation of, so if it's 2038 and there's no coal on, it's still saying, can I meet this target? So that last validation step does not use the full rated, but it does in the reserve margin in the front step.
Okay, and so again, just to be clear, that additional step that you're talking about, that is not in the capacity expansion modeling.
That validates that the capacity expansion model gives you a portfolio that is still reliable when it's using just the ELCC values.
Okay. Thank you. Those are all of my questions.
Thank you, ma'am. Walmart, any questions?
No questions, thank you.
Sasiba?
No questions, but thank you.
All right. Anything else from any commissioners? Well,
Chair Bowers.
oh, I'm sorry.
That's all right. Just for the record, no questions from ORS. Thank you.
Okay. Before I excuse these witnesses and release this panel, the court reporter thought that hearing exhibit number 31, which was a cross-examination of Glenn Snyder by Mr. Torrey, and it was a copy of April 30th, 2024 verified second amended petition filed in North Carolina, docket E100, sub 190. Does that sound familiar? It was.
Yes, sir.
I don't think it was marked or entered officially into the record, and I wanted clarity and completeness of the record to make sure that it was marked and admitted as a hearing exhibit 31, subject to any ruling or any admission inserted on Friday. Is that?
That's accurate, Mr. Chair.
Okay. All right, gentlemen, you've earned your lunch anyway.
Thank you, Chair.
Your next witness, next panel.
Thank you,
Y'all
sir.
are excused.
And I think you did this, but we'd ask that these witnesses be excused.
Yeah, they are excused.
Thank you, sir. The companies would call to the stand Ms. Laura Bateman and Heather Shirley Smith.
Don't forget your award, Mr. Snyder. Sure.
Raise your right hand, please. Do you swear affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I'm sorry, go ahead.
No worries. Ms. Bateman, I'll start with you. Would you please state your name for the record?
My name is Laura Bateman.
And by whom are you employed and in what capacity?
I am employed by Duke Energy Carolinas as the Vice President of Rates and Regulatory Strategy.
Did you prepare 11 or cause to be prepared 11 pages of pre-filed rebuttal testimony filed with the Commission on August 14th, 2024?
Yes.
And if I ask you the same questions that were contained within your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Chair Powers, I would ask that Ms. Bateman's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Bateman will be entered into the record as if given orally from the stand.
Thank you, sir.
Rebuttal testimony.
Yes, sir. Ms. Smith, would you please state your name for the record?
Heather Shirley Smith.
And by whom are you? Oh, your microphone's not on. You'll state your name for the record, please.
Heather Shirley Smith,
Thank you. And by whom are you employed and in what capacity?
Duke Energy, and I am our Vice President of Regulatory Affairs and Policy for South Carolina.
Did you prepare or cause to be prepared 72 pages of pre-filed rebuttal testimony that were filed with the Commission on August 14th, 2024?
Yes.
Do you have any changes or corrections to that pre-filed rebuttal testimony at this time?
Yes, I have one small correction. On page 49 of my pre-filed rebuttal testimony, line 21, I state, as explained by witness Bateman in her direct testimony, that should be in her rebuttal testimony.
Thank you, ma'am. And subject to that correction, if I were to ask you the same questions that were contained within your pre-filed rebuttal testimony this afternoon, would your answers be the same?
Not exactly. There was some information received from ORS in their rebuttal that changed my view a little bit of what their modeling requests were. They made new modeling requests in their rebuttal. And so the rebuttal that I had to their original request, I'm not sure, I mean, it stands, it was pre-filed and I still believe it, but the new modeling that they've asked for, we're amenable to talking about that and trying to find a path and through stakeholder engagement before the next comprehensive IRP. And then they had made some additional comments on all source procurement. And so I had some additional observations about that suggestion that were included in a portion of the September 11th letter that I wrote pertaining to our reaction to the ORS rebuttal.
And so subject to those caveats and the correction that was noted previously, if I asked you the same questions, would your answers be the same?
Yes.
Thank you, Ms. Smith. Chair Powers, I would ask that Ms. Smith's pre-filed rebuttal testimony, subject to her caveats and the correction we noted, be entered into the record as if given orally from the stand.
Mr. Chair. Mr. Chair.
Yes.
I hate to interrupt, but in light of ORS's outstanding motion to strike certain portions of Ms. Smith's rebuttal testimony, I just wanted to note ORS's continuing objection.
Your objection is noted and still stands. The pre-filed rebuttal testimony with caveats of Ms. Smith will be entered into the record as if given orally from the stand.
Thank you, sir. I appreciate that. Ms. Bateman, we'll start with your testimony summary. If you don't mind, would you please read that for the commission at this time?
Chair Powers, we have not gotten Ms. Bateman's. We think it might be with the court reporter.
Ms. Bateman, you may proceed.
Okay. Good afternoon, Chair Powers, Vice Chair Williams, members of the Commission. In my testimony, I explain how the companies, Duke Energy Carolinas and Duke Energy Progress, have operated a dual-state system for more than a century and believe maintaining a dual-state system is in the best interest of customers. The company's preferred portfolio, P3 Fall Base, as presented in this case, represents a dual-state integrated resource plan, which we believe provides the best pathway for the companies to serve the future energy needs of our customers and does not result in incremental costs solely due to North Carolina law. I further explain that if this commission does not agree that the company's recommended portfolio is the best path forward for South Carolina customers, it is important that the companies receive such guidance before we begin executing upon resources. If there is a divergence in the preferred resources between the two states in the dual state system, I describe a framework that could be developed to accommodate the differences while maintaining the dual state system. Lastly, I provide an update on the company's plan to merge into one utility, which would consummate the integration of the two utilities as originally envisioned at the time of the 2012 merger of Duke Energy and Progress Energy. It was noted in this Commission's order number 2012-517 that the plan was to merge the companies into a single entity at some point in the future. I explained how a merger is the best solution to address the company's future operational needs and provide significant benefits for customers. This concludes my testimony summary.
Thank you, Ms. Bateman. Ms. Smith, would you please provide to the commission your testimony summary?
Sure, thank you. Good afternoon. Happy to be here. In my rebuttal testimony, I primarily respond to the direct testimony of the Office of Regulatory Staff. In its testimony filed July 1, 2024, the ORS didn't oppose the company's recommended portfolio, any particular resource in the IRP, any generation type, our updated planning reserve margin, or our load forecast. And there are foundational components of the IRP that the companies and the ORS agree on, at least in my view. For example, the ORS acknowledges that load growth is presenting challenges and opportunities for South Carolina and asks for reporting that we are amenable to. The ORS also acknowledges the increase in our reserve margin from 17% to 22%, a meaningful increase and one that we will have to grow into over time. The ORS testimony, in my view, appears to be supportive of actions to execute upon obtaining resources to meet our reserve margin as quickly as possible, recommending that the companies take all reasonable and prudent measures to mitigate reliability risks that may occur from 2024 to 2030. Maintaining reliable service for our South Carolina customers is non-negotiable job number one, and we are actively bringing incremental dispatchable capacity resources online. We've notified this commission that we are currently pursuing approval to proceed with over 2,000 megawatts of new natural gas combustion turbines and combined cycle generation located in North Carolina, and we have entered the interconnection study process for a new natural gas CC facility in South Carolina. These resources are targeted to be in service between 2028 and 2033 and will provide significant capacity to the system. Additionally, the company's 2022 CPRE for solar resources was completed in June 2023 and resulted in almost 1,000 megawatts of new controllable solar contracts and utility-owned projects, targeted to be online starting in 2026. The company's 2023 CPRE program seeks over 1,400 megawatts of solar and storage paired with solar, targeted to be online between 2027 and 2029, and we are in the process of finalizing our 2024 CPRE program and planning for our 2025 solicitations. We are also pursuing battery energy storage additions, both co-located with solar through those CPRE procurements, as well as standalone batteries that often can leverage company-owned land. So as you can see with these actions, plus other longer lead near-term action plan activities, we are continuing to meet our obligations to serve existing customers with diverse resources and advancing new resources to meet new load. Moreover, there are a number of recommendations from the ORS, many of which relate to stakeholder engagement, that we are able to accept. Stakeholder engagement builds upon itself. We've been engaging on resource planning matters that affect customers and litigants in both states for several years now. In the most recent round of engagement, we focused on the technical aspect of these cases and relied heavily on consultants that have been involved in our cases for years. As noted by ORS, stakeholder engagement should help to resolve issues and improve the modeling process. Because these stakeholder engagement sessions provide a venue to resolve or streamline issues, or to allow the companies to discuss requested modeling assumptions or scenarios ahead of time, it can be disruptive, expensive, and unduly burdensome when new recommendations are made in the latter part of a case that could have been handled or discussed beforehand. We are willing to address matters through stakeholder engagement, but it would also be good to hear from the Commission on this matter. We do believe that it's important if an entity makes recommendations for stakeholder engagement and the Commission ultimately includes those in its orders, it should be an expectation that the recommended entity participate in those sessions. Despite the areas of agreement, there are still areas where we disagree with the ORS and their consultant, including the need for additional further consideration of portfolio P0, the extent of the Commission's decision-making authority granted by Act 62 of 2019 as it pertains to resource planning and execution activities, and the need for an all-source procurement requirement. In the supplemental planning analysis, we confirmed that Pathway 3 was still the best path for customers, and we updated it to P3 Fall Base to capture the fall 2023 load forecast and significant economic development growth. Further, upon finalization of the Clean Air Act Section 111 final rule, the companies analyzed the implications of the now final rule and applied those implications to our planning analysis. That analysis confirmed for us that the balanced mix of resources in the P3 fall-based portfolio remains the most reasonable, prudent, and least risk portfolio for South Carolina customers. Indeed, while the final rule might ultimately be stayed, the fact that our all-of-the-above resource mix in PAL 3 fall base is compatible with the final rule affirms that our recommended portfolio is well suited to meet the energy challenges we face. In contrast to the diverse resource mix of P3 fall base, P0, the portfolio resulting from ORS's prior recommendation for new modelings, is not executable as it is not compliant with laws and regulations applicable to the company's operations. It does not comply with South Carolina law and policy, to my thinking, the final 111 rule, or laws applicable to the company's operation in North Carolina, where many of the resources serving South Carolina customers are and will be located. This lack of compliance makes P0 unexecutable. Further, P0 is overly dependent on new natural gas generation, which would present significant challenges and risks with respect to the number of new gas units required to be sited, permitted, constructed, and operated. Such a portfolio, even if executable, would result in gas supply and fuel security risks, as well as significant increased customer exposure to gas price volatility. The ORS consultant's request for additional modeling of P0, as well as revisiting coal plant retirement dates, are not consistent with South Carolina law or policy, and we do not believe it is in customers' interest to provide additional modeling based upon assumptions that are not compliant with the legal requirements applicable to the company's planning and operations, or that otherwise are based on a portfolio that doesn't account for significant reliability and cost risk to customers or South Carolina's economic development opportunities. We understand that the Commission is required to approve the most reasonable and prudent plan at the time of review, and that plan encompasses a 15-year planning period. Naturally, there is more certainty associated with and necessary for the early part of that period. There are resources we plan to pursue over the next 15 years, but within that time frame are things we need to act on before the next IRP is filed in South Carolina. These are actions that are described in our near-term action plan. The ORS takes the position that the Commission is not authorized to make the requested ruling on our near-term action plan, but the Commission has previously provided to other utilities the guidance we are asking for in this case, and our requests are well within the bounds of South Carolina law and policy. As I explained in my rebuttal testimony, we are not asking the Commission to change the regulatory construct in South Carolina, and to be clear, we are not asking for any rate determination in this proceeding. In enacting Act 62 in 2019, the General Assembly changed the regulatory paradigm in South Carolina and empowered the Commission for the first time to have a broad range of forward-looking authority and for interveners and parties to participate in cases involving the comprehensive future resource plans of utilities. Indeed, this Commission itself has recognized that the General Assembly significantly strengthened the IRP process, imposed a detailed list of requirements, established a litigated proceeding, and signaled heightened importance to resource planning and the critical role of the Commission in ruling on IRPs. Although the IRP statute provides that the Commission action on an IRP is not determinative of the reasonableness or prudence of the acquisition or construction of any resource, that doesn't mean that the Commission's orders in IRP proceedings are without any effect whatsoever in future proceedings, or that utilities are free to ignore them or not reasonably rely upon them on a going forward basis. We believe that IRPs must be reasonably executable to be approved by the Commission, and from the date of the IRP order, the companies retain the burden of ensuring that their actions are prudent and reasonable. And it is those post-IRP order decisions that we believe will be judged in CPRE, Siting Act, and rate case proceedings. This is consistent with the Commission's recent determinations that the near-term action plans of Dominion Energy South Carolina and Santee Cooper were reasonable and appropriate as a guide for its generation and transmission planning and procurement activities in the near term, subject to updates. We agree with the Commission. A utility's near-term action plan should serve as a guide for its generation and transmission planning and procurement activities in the near term, subject to updates that may be needed to reflect changes in circumstances. This need for an action plan is especially heightened when the system is simultaneously experiencing load growth and legacy plant retirements. With respect to the suggestion that the companies consider developing an all-source RFP, the companies do not believe the suggestion is good for customers or that the Commission is authorized to mandate such action. Next, I want to address the ORS testimony that indicated our IRP includes the substantial influence of HB 951 and North Carolina carbon reduction goals. The ORS consultant's report opines that our modeling approach appears to be aimed at House Bill 951 compliance. They do not acknowledge or otherwise address or dispute that our IRP also reflects the substantial influence and compliance with South Carolina law and policy. We must remember what HB 951 actually requires: emissions reductions, accounting for coal retirements with replacement and incremental new generation, and other resources to serve existing and future load, while maintaining reliability and affordability for customers. None of this runs contrary to the interest of South Carolina or South Carolina law and policy. These core tenets of reliability, affordability, and increasingly clean energy have been in the company's resource planning goals for years, and our goals are not so different than what all utilities are trying to achieve in one way or another in South Carolina and across the country. Our recommended portfolio P3 fall base is also consistent with federal requirements and demands of customers for cleaner energy. As a dual state system, it makes sense that our plans would be in compliance with applicable statutes and regulations of both states. What ORS does not acknowledge is that two things can be true. North Carolina law can be consistent with South Carolina law and policy, and a resource plan that addresses North Carolina law is not automatically detrimental to South Carolina interests. Here, there are multiple ways in which P3 fall base is the most reasonable and prudent portfolio on a standalone basis under South Carolina law, and those reasons should not be undercut because our plan also complies with North Carolina law. This concept is extremely important to the consideration of this case, that two things can be true when it comes to compliance with South Carolina and North Carolina, and the ORS has not provided any reference, theory, or analysis that contradicts that perspective. I also note that while we may be the only dual state utility in South Carolina, we are not the only South Carolina utility retiring coal plants, dealing with aggressive load growth, and bringing online new gas and renewable resources. In sum, our recommended portfolio P3 fall base remains the most reasonable, prudent, and least risk portfolio for South Carolina, setting forth plans for a balanced and diverse resource mix to meet significant load growth while retiring our aging coal fleet. P3 fall base is fully consistent with governing South Carolina law and policy as it addresses commodity price risk, generation resource diversity, power supply reliability, and foreseeable risk, among other factors. We need to keep executing on the IRP's near-term action plan to meet growing load, and the Commission's guidance and direction is essential so that we know that we are on the right track as we execute on our plan, invest in our system, and speak to customers about what our system is likely to look like in the future. We can certainly revisit where we are and where we will go in future IRP cases, but it is important that the companies have a solid basis, an executable IRP decision with sufficient clarity on the resources South Carolina desires to be served by, from which to guide our actions in serving all of our customers, including those located in South Carolina. Importantly, as the General Assembly has recognized, the economic development customers looking to locate in South Carolina or expand their operations in this state depend upon the companies for an increasingly diverse, clean, and reliable portfolio of generation resources. The companies will be relying on the Commission's guidance to confidently execute on the next generation of resources needed to serve the state's current needs and its growing economic development needs in an optimum manner. This concludes my testimony summary.
Thank you, Ms. Smith. Ms. Bateman, Mr. Chair, these witnesses are available for questions from council or the commission.
Thank you very much. Sarah Club?
Yes, thank you. Can you hear me okay, Chairman Powell?
Hear you well, yes ma'am.
Great, thank you. So my questions, this is Dory Jaffe on behalf of the Sierra Club, and my questions are for Ms. Smith. Ms. Smith, were you in the room on Friday when Mr. Snyder and Mr. Quinto deferred questions to you on the settlement agreement that Duke signed with the North Carolina Public Staff, SECEBA, and Walmart in the North Carolina Carbon Plan docket?
I thought those were referred to me and Ms. Bateman, but that could also be wishful thinking, but I did hear that exchange.
Okay, great. Well, if either one of you can answer these questions, it would be appreciated. But I do believe, Ms. Smith, that you referenced this settlement agreement on page 71 of your rebuttal. Is that correct?
Yes.
Okay. And I'm going to actually ask my colleague, Mr. Guild, if he could put paragraph 46 of that settlement agreement on the screen, just so I don't have to try to share my screen. Great, thank you. So Ms. Smith or Ms. Bateman, on Friday when I asked Mr. Quinto if the consultant he referred to on page 18 of his rebuttal with respect to the Energy Infrastructure Reinvestment Program was the same consultant that will be hired pursuant to this paragraph 46 of the settlement agreement, are one of you able to answer that question for me? Is the company referring to the same consultant in both the settlement agreement and what was referenced in Mr. Quinto's rebuttal?
To my understanding, yes.
Okay. And so paragraph 46 of that settlement agreement, as you can see from the highlighted sections, states that the North Carolina Public Staff will be included in all meetings and correspondence with the consultant. Do you see that language?
I do.
Will any South Carolina stakeholders or ORS be included in that correspondence or in any meetings with the consultant?
I think that is a great question for the ORS. If the ORS would like to be included in this discussion, we would be happy to have them. I would also like to note that these are discussions that we frequently have with the ORS on an offline basis. The ORS has, in my view, been very concerned with customers getting the benefit of federal dollars. And we frequently have conversations or have communications, including in the docket, that relates to IRA and IIJA matters and monies that are regularly filed in South Carolina. We have a history of agreeing to things in North Carolina, which me sitting in South Carolina get pretty excited about because we get the benefit of some of that information. I think of different climate studies. I think of ISOP. I think of other types of studies we've agreed to in North Carolina settlements that help our conversations in South Carolina as we continue to move the ball on important initiatives. So the short answer to your question is happy to have them, but it would be up to them to determine whether that's a good use of their time or not, and how the public staff would view that, this is a settlement agreement in North Carolina. We do not have a settlement agreement in South Carolina. So I couldn't speak for the other parties to this agreement. But we're always happy to talk to the ORS and include them on our opportunities and how we see opportunities to harvest and harness federal dollars for the benefit of our customers.
Great, thank you. I appreciate that. So will any drafts of these reports from the consultant also be circulated to either South Carolina stakeholders or to ORS?
I think it's a little early to tell that. Again, this is a North Carolina settlement agreement, and we do not have a settlement agreement in this case. So there's a whole lot of parties that are involved in this settlement agreement that do not have a similar agreement in South Carolina. But I think of other instances where the same thing has been true, and we have filed the results of those types of things with this commission. I think over the years, I think of ISOP, I think of a rate design study, I think of some of our climate reports. So I don't think that we would hoard information by any stretch of the imagination.
Okay, that's great. And then one final question is this paragraph also refers to a May 1st, 2025 filing deadline with the North Carolina Commission for the final results of that consultant's assessment. Would you anticipate filing that same assessment with this commission?
I think it's too early to say that. I just think it's too early to say probably, but I don't know. Sitting here today, it would depend on what it says. And that kind of thing. I can't imagine that we wouldn't, but I just don't want to commit us to something that far in advance, particularly something that arose uniquely from a North Carolina settlement agreement.
Right, but you would agree with me that whatever the results come out of this consultant's report about the cost and benefits of this, federal program that has up to $250 billion available to utilities could be useful to the South Carolina Commission to understand what benefits, could trickle down to South Carolina ratepayers. Would you agree with me on that?
I would absolutely agree that all federal money could be helpful for South Carolina customers, and this commission has a process by which it takes comments and looks for the utilities to provide updates on such matters. So whether we provide updates through the commission's process that it's already established or through something different, I just don't know that sitting here today.
Okay, thank you. No further questions.
Thank you, Ms. Eaton. Next, CCLC, any questions?
No questions.
Thank you. Sasiba?
No questions. Thank you.
All right. Walmart?
No questions, and I will clarify that I think you accidentally referenced Miss Jaffe as having the questions before me, so she was the one that had the questions, but I do not have any. Thank you.
Thank you very much. ORS?
Thank you, Mr. Chair.
I didn't overlook you that time.
Thank you, sir. Good afternoon, Ms. Bateman.
Good afternoon.
Good afternoon, Ms. Smith.
Good afternoon.
Ms. Smith, the companies refer to the IRP that's presently before this commission as the Carolinas Resource Plan. Isn't that correct?
That's correct.
And so the companies filed the same Carolinas Resource Plan with the North Carolina Utilities Commission, correct?
Yes, that's because there is only one Carolinas Resource Plan for our system that serves the entire basin located in the Carolinas.
So the CPIRP that is currently pending before the North Carolina Commission, and I think was related to the settlement agreement we just reviewed, is identical to the IRP this commission is considering.
Yes.
And both the CPIRP and the IRP contain a South Carolina chapter and a North Carolina chapter. Is that correct?
That's correct.
And those documents are also exactly the same. Would you agree?
They're not exactly the same.
How are they different?
North Carolina's North Carolina. I don't mean to be glib, but North Carolina's North Carolina and South Carolina's South Carolina. Maybe I misunderstood your question.
Well, if I went through, because I tried to this morning, and compared word by word, I didn't, this is filed in this commission, this is filed in North Carolina, and I didn't see any differences.
Oh, I misunderstood your question. Yes, they're the same.
Okay.
And
Go ahead.
just subject to Ms. Smith confirming, but I believe that's the case in every IRP that the companies have filed in both states, even before HB 951, that we operate a dual state system. And so we file one resource plan that serves both states. And typically South Carolina is about 20% of that resource plan, and North Carolina is about 80% of that resource plan.
Thank you, Ms. Bateman. I put up here on the Elmo the first page of the North Carolina chapter. Ms. Smith, would you agree that the North Carolina chapter cites North Carolina House Bill 951?
Sure.
Would you also agree that it cites the North Carolina Utilities Commission initial carbon plan order?
Sure. I think it references North Carolina law and policy much in the same way the South Carolina chapter addresses South Carolina law and policy.
And in fact, the North Carolina chapter provides some was helpful to me, background information on HB 951 and the North Carolina Commission's initial carbon plan. Would you agree?
I mean, I would agree. I would also say that while I have reviewed this, I certainly didn't study it. What I studied for my testimony today was the South Carolina chapter and the South Carolina operative statutes and guidelines. So I'm happy to address anything, but I don't want to communicate that I'm a North Carolina expert here.
Certainly, I understand. And so let's just read the first, if you would follow me as I read the first sentence of this page 14 of the North Carolina chapter of this IRP. The commissions, and just for clarity, in this context, it's the North Carolina Utilities Commission, is that correct?
Yes.
The commission's initial carbon plan order approved a series of near-term actions as the initial reasonable steps that the companies were authorized to pursue under the HB 951 framework of selecting resources to achieve HB 951's planning objectives. Did I read that
Mr. Chair, I would object. I've been sitting on a relevant subjection. I was waiting for it to go somewhere that's related to South Carolina. Ms. Smith filed 72 pages of rebuttal testimony in the South Carolina docket, and we're focused on a North Carolina chapter filed in August of last year.
It's cross-examination, Mr. Welborn. I'm going to allow it. I hope he is going somewhere with it, though.
Me too. Thank you, sir.
I am, Mr. Chair. Ms. Smith, do you see the word selecting there, and it's set off by quotation marks?
I do.
Do you have any idea why it's set off by quotation marks?
I don't. I imagine in concept it's looking at and considering what models and what resources are selected in certain models and what the North Carolina Commission ultimately selects from those models.
And I believe one or more of the commissioners asked witnesses this morning whether South Carolina law requires this commission to select specific resources. Do you recall that questioning?
No, I don't recall that question.
Okay. Can you read with me the highlighted text there? Let me ask you this. Are you familiar with North Carolina Rule RA-60A?
Very generally.
Okay. Let's just see what this footnote says, because So it appears that this footnote 27 is tied to this sentence about selecting. So let's just see where this takes us. Would you agree that it says proposed rule, RA 60A D7, now also requires the companies to identify proposed supply-side resources for selection as needed to progress the least cost energy transition path to achieve the interim target and plan for carbon neutrality over the long term?
Yes, it says that.
For selection by whom?
I mean, whether it's the company that selects them for submission to the commission or the commission that selects them for the resource plan, I think the rule, as I understand it, directs a focus on what resources are going to be put forth and counted upon to serve customers in the future, which I think of as very akin to the process that we're doing here in South Carolina. I'm not aware that the South Carolina Commission has a similar rule, nor do I know, I don't know that one's really needed because that's what the statute tells us to do in South Carolina.
Yeah, and maybe we're getting a little hung up on words, but you know, that select is not part of the, so I did hear the question about selecting resources. Does this commission select resources? And my understanding in South Carolina that the company is responsible for recommending a portfolio of resources. So we select and recommend a portfolio of resources to this commission, but then it is this commission's responsibility to approve, modify, or reject that portfolio of resources. So just a little nuanced there, but I don't know if that helps clarify.
Yeah, I think I would also add another difference between North and South Carolina, to my understanding, is this commission has required us to put forth a preferred portfolio, to put forth a preferred plan. We've covered that in our last IRP where we gave a wider range of options. And we looked at that at the time, that all of those scenarios and portfolios were really what an IRP was. And then this commission gave us the direction to put forth a plan for commission consideration. Whereas I think it operates a little bit differently in North Carolina, where there's more of a menu of options, and the North Carolina Commission takes that action, whereas here the commission has wanted us to put forth what we recommend.
Thank you, Ms. Smith. Harkening back to a question from Commissioner Jay Williams, and again, this was last week, so I don't remember the day, but he asked one of the witnesses, basically, what makes this IRP different from past IRPs? Do either of you remember that question?
I do.
And this is, and I'd like to get your opinion on that. This is what I'm showing you here. Or do you recognize this document, Ms. Smith?
I don't. I mean, it looks like our document. I don't know. I'm guessing it came from the IRP in general. Is it Chapter 4?
Yeah. Do you see the watermark on the side?
Yes. I'm thinking this is Chapter 4 from the total IRP.
And do you see that the highlighted sentence, first sentence of the first full paragraph, Ms. Smith?
I do.
Could you read that for me, please?
The execution plan presented in this chapter provides a detailed roadmap and reflects an intentional evolution of the short-term action plan framework presented in past integrated resource plans, IRPs. So I think that's not a surprise. I heard several of our other witnesses talking about this. The South Carolina Commission had directed us to my recollection, to put more information in our short-term action plan. And so I don't find that statement unusual.
Okay, could you please read footnote 1?
Respectfully, Mr. Chair, just real quick, I'm going to renew my objection. We're still focused on North Carolina law, and I'm struggling to see the relevancy to the South Carolina IRP proceeding.
Well, if I may respond, Mr. Chair.
Certainly.
There's been some questions from this commission about why this IRP seems to be so much different than previous IRPs. I think this goes to the heart of the matter.
Well, there's also testimony by Ms. Smith about the basic statutory flexibility provided under North Carolina law here and different things about North Carolina law. I'm going to have to overrule your objection.
Ms. Smith, would you please read footnote 1 for me?
The companies first presented the concept of an execution plan and the 2022 proposed carbon plan, and both near-term action planning as well as identifying resources for selection by the NCUC are now required by proposed Rule R860AC. This is the company's first opportunity to present the more detailed execution plan to the Public Service Commission of South Carolina together with North Carolina. I paraphrased that last bit.
Okay. Would you agree, based on that, Ms. Smith, that the companies are asking this commission to do something that they have never done before?
My recollection is that they looked at short-term or near-term, whatever you want to call it, they looked at short-term action plans for the other utilities as well as Duke in prior proceedings. I look at these as defined terms, but I think that we would be in a pickle if we put forth a 15-year plan in a period of high load growth and we didn't have some execution activities in those near-term years. So I don't find anything unusual about the mechanics that are included in footnote 1. I sure would hope that we would have in mind what we were going to do to meet load growth and that kind of thing as the state grows.
Okay, Ms. Smith, we established that the North Carolina chapter of this IRP cites and discusses the initial carbon plan order issued by the North Carolina Utilities Commission, haven't we not?
Yes.
Okay, let's look at the carbon plan order. Got Mr. Austin here handing out some very thick documents. Ms. Smith, do you have the carbon plan order in front of you?
I do.
Okay, and I've put the first page up here on the Elmo, and I can promise you we are not going to go through however many pages this thing is, but if you would you please turn to page 26 for me? Okay, Ms. Smith, it's the last sentence on page 26, and it continues on to the first page of page 27. And just follow along with me, and I believe, again, the context here, the commission, the North Carolina Commission is basically weighing the positions of the various parties. Could you read that highlighted part for me, please?
Are you telling me this is where the order? I'm not deeply familiar with this order. It's from 2022. I didn't work on this case. I followed along to make sure that I understood how 951 was being implemented, but I didn't work on this case. I wasn't counsel to this case. I wasn't a witness in this case. I wasn't present in the hearing room. So if it is pertaining to positions of the parties, I don't have any basis to disagree that this order says what it says.
Do you have any basis to believe that this order, that this is not a true, accurate representation of the carbon plan order?
No, I don't.
You do not what?
I don't have any basis to believe that this isn't a true and accurate accounting of what took place in that docket. I'm just making clear for the record that I sit in a chair in Greenville, South Carolina, and think about South Carolina every day.
Okay, can you read that sentence for me, please?
Relatedly, Duke contends that it has never been required to incur, prior to commission approval, development costs of the magnitude that are required to ensure the availability of the long lead time resources on the timelines contemplated by the carbon plan without some form of cost recovery assurance.
Ms. Smith, were you in the hearing room last week when Commissioner C. Williams asked a Duke panel about the allocation of risk in pursuing generation resources in the regulatory compact?
I've been in the hearing room for all of Commissioner Williams' questions. The way you're paraphrasing them, I'm not sure matches the notes that I took, but I'm happy to listen to your question and try to answer it the best that I can.
And I may be able to respond to it as well. And I remember that question.
Okay. Well, and related to the question that Commissioner C. Williams asked, could you please read the next sentence I've highlighted that starts with further?
Further, Duke states that it would be inconsistent with the regulatory compact to impose a legal obligation to perform substantial development work on Duke while denying any such assurance of future cost recovery.
And I promise you this is the last question about this document. Could you please read that last sentence?
Sure. Finally, Duke contends that in the absence of cost recovery assurance, customers could potentially lose the benefit of any resources Duke deems too risky to pursue. I think this concept is very important because the ORS has repeatedly asked questions about the cost associated with our near-term action plan and our request in North Carolina specific to those costs. I think we have been very vocal in recognizing that that is not a construct that we have in South Carolina. But I will also say that I hope the North Carolina Commission agrees with those requests. If they agree with the development of new nuclear associated costs, it will make me very happy on behalf of South Carolina customers because that means that we have 80% of those costs covered by North Carolina. If the North Carolina Commission decides to grant cost recovery of the additional funds needed to advance Bad Creek 2, I certainly hope that the order that comes out of the North Carolina Commission approves that cost because that will tell us then that there is 80% cost coverage on those costs. So every time the North Carolina Commission has an order that grants cost recovery, I see that as a benefit to South Carolina, not a mandate by any stretch of the imagination. And of course, we did not ask for the same thing here in South Carolina because we do not have the same operative paradigm.
But, go ahead, Ms. Bateman.
I just want to jump in because I've heard, because I do work across both North and South Carolina, unlike Ms. Smith. And so I have heard during the course of this hearing several times the word guarantee, pre-approval, when describing what the North Carolina Commission does. And I think that's maybe a mischaracterization. And I know there were questions earlier on the settlement with the North Carolina Public Staff, and I hate to bring North Carolina into this, but since other parties have, I just want to be clear, in that settlement agreement, there is a reasonable assurance of cost recovery, but it does require the utility to act reasonably and prudently. And I'm just going to read a couple sentences. For the avoidance of doubt, any commission approval of a request from Duke to incur initial project development costs would not constitute pre-approval of cost recovery. Rather, the approval would be indicative that the commission finds such actions to be a reasonable and prudent step in furtherance of the carbon plan, but that cost recovery will be conditioned on a full review for reasonableness and prudency during the appropriate cost recovery proceeding. So I do think that's a slightly...
Commissioner Williams.
Thank you. Ms. Bateman, I just wondered if you could give us the page number you were reading from. Thank you.
That is bottom of page 16. It's in paragraph 37. On my copy, it's bottom of page 16, top of page 17. And so I will say, I think it's a slightly different standard than what we're asking for here in South Carolina before this commission. But it's not a guarantee or a pre-approval. Maybe I wish it was, but it's not. It's a reasonable assurance of cost recovery if we act reasonably and prudently in incurring those costs and we don't exceed the estimates that we've provided. So again, slightly different than what we're asking for here, but I just wanted to clarify that. And I will also clarify the statute that was referenced there, the 62-110.7, that predated HB 951. That's like a 2007 statute in North Carolina.
And Ms. Bateman, so I'm glad you brought those up. So 110.7, does that deal with nuclear development?
So I actually would have to refresh. It deals with nuclear development, but also other types of construction as well. And I did not bring my North Carolina statutes here.
That's right. That's quite all right. But I think you were looking at page 15 or 16 of the North Carolina settlement agreement. Is that right, Ms. Bateman?
Yes.
So I did just want to follow up on that, paragraph 36. The stipulating parties agree that it is reasonable and prudent for the companies to incur initial project development costs associated with the initial project development activities for execution of the carbon plan as follows. And then we have $65.6 million for the development of 3 tranches of onshore wind, $165 million for the development of pump storage hydro, which I believe is Bad Creek. Is that correct?
Correct.
Initial development costs up to $1.4 million, and I believe that's regarding the offshore wind.
Yes.
And then we have project development costs up to $75 million through 2024, plus an additional $365 million through 2026 for the development of advanced nuclear. Is that correct?
That's correct. And I will note too, anytime you see carbon plan here, you could pretty much substitute in IRP in North Carolina. And so these are the near-term actions required to pursue the dual state integrated resource plan that we've proposed in both states.
And that, Ms. Bateman, is because post HB 951, the legacy IRP rule was sort of merged into the now carbon plan IRP rule. Is that correct?
I don't know the exact legal framework, but when North Carolina talks about a carbon plan, they mean a 15-year integrated resource plan.
With a 2-year near-term action plan associated as a component of that, right?
So I don't know that that's necessary, but we have included, I know that they're required to update that IRP every 2 years. And so it would make sense that there is a updated near-term action every 2 years.
And this is for either of you. Are you familiar with the South Carolina Utility Facility Siting and Environmental Protection Act?
I am.
And under the Siting Act, no person shall commence to construct a major utility facility without first obtaining a certificate of environmental compatibility and public convenience and necessity. Would you agree?
Yes.
And Ms. Smith, would you also agree that the Siting Act requires that the utility applicant demonstrate that the facility to be built has been compared to other generation options in terms of cost, reliability, and any other regulatory implications deemed legally or reasonably necessary for consideration by the Commission?
Yes.
Now, the company has indicated that they will be filing with this commission an application for such a certificate for Bad Creek 2. Is that right?
That's correct. Well, it's not exactly correct. So I would like to point you to the near-term action plan. And so we have asked the commission, as part of the 15-year IRP, years 1 through 3 of that contain actions that we plan on pursuing. So we have said in there that subject to necessary regulatory guidance and support, target a South Carolina Siting Act application. And Mr. Smith here last week talked about the additional steps that we would be taking in between now and such a filing as we continue to evaluate that resource. I would also say that the outcome of this proceeding, as well as the outcome of the North Carolina proceeding, will be a big influencer to our actions, as well as the culmination of those evaluation activities that Mr. Smith described.
Okay. And I believe there is testimony in this case that the companies are at least considering siting one of the new combined cycle facilities in South Carolina. Is that correct?
That's correct. And I think if you go to the near-term action plan, the exact words that we have, we describe all of our activities related to CTs and CCs, but we talk about that in 2025 we would anticipate filing for a South Carolina certificate for a CC located in the state with a 2031 in-service date, and we go through the activities that would be a part of that process, submitting an air permit. As I'm sure you're aware, there's a number of statutory parties involved in a Siting Act application, DHEC, now DES. There's some other statutory interveners, other South Carolina agencies. And part of that was also we've got to be in DICES, the interconnection queue. And so as of June, we have put that facility in the interconnection queue for additional evaluation as to the impacts to the system. And then we have a number of other activities related to new natural gas facilities. And again, these activities that we're asking for approval of would be to continue to pursue those types of applications. So nothing in the near-term action plan asks for permission for us to break ground and start constructing anything. nor does it, ask for any particular relief from that kind of proceeding in the future.
Ms. Smith, not all of the resources in the company's near-term action plan are going to be cited in South Carolina, are they?
No, they're not. That's one of the reasons why the near-term action plan is so important to us, because we think it is incredibly important that the commission understand how we are going to meet our load growth, maintain or improve reliability, and safely and responsibly retire our aging, some of our aging fossil units. So we thought it was incredibly important to provide a detailed list of the steps that we plan to take to meet South Carolina's energy future. Those steps are not geographically restricted to the state of South Carolina. And so while not all of these actions will come before this commission, we did not see that as an out or relief from providing this kind of detail to the commission and transparency.
So for the generation resources that will be built in North Carolina, is it correct that you will not come before this commission to seek a certificate of environmental compatibility and public convenience and necessity?
We do not have an avenue to do that.
I believe one of the generation sources that we've discussed this past week and a day is an SMR at the company's Blues Creek facility. Do you remember that?
Yes.
And that's in North Carolina?
It is.
Ms. Smith, for the generation resources, such as the SMR at Blues Creek, that the company is going to build in North Carolina, this commission will not have the opportunity to review the actual costs associated with those resources until they're presented in the next rate case. Is that correct?
No, I wouldn't agree with that at all, because we will be coming before this commission literally every year. There's not a year in between now and when those units would come online where we will not be bringing to the commission what our resource plans are, including in-flight projects. A great example of that is we filed as information in this docket activities related to filing for certificates in North Carolina for our CCs and CTs that we are seeking certificates for. So I just don't agree that we won't be back in front of this commission in a transparent way, sharing where we are on these projects and making sure that the commission gets any questions it has regarding those projects answered, as well as the ORS. We certainly don't need this hearing to be transparent with the ORS as to where we are on the status of those projects and what we're seeing. In addition to that, I'm pretty excited about this opportunity for us to locate those SMRs on a retired coal facility in North Carolina. As witnesses before me described, the very nature of locating SMRs on that site means tremendous benefit to South Carolina customers, to all of our customers, in leveraging that geographic location and getting additional federal dollars that would not be available to us otherwise, which get passed on directly to customers.
Ms. Smith, on page 47 of your rebuttal testimony, starting at line 17, you state, quote, "In the company's view, approval of an IRP should have meaning, and matters that could have been litigated or raised in an IRP should not be relitigated in future procurement, siting, or rate proceedings, unless there's a change in circumstances from the date the IRP order is issued that warrants such issues be revisited." Is that correct?
That's correct.
What are some issues that, in your opinion, could have been or should have been litigated in this IRP proceeding that were not?
I think a big thing would be what the ORS thinks that the energy of future, what ORS thinks of as the energy future for South Carolina. So the ORS didn't take a position on any particular portfolio, didn't support or necessarily object to any of the particular resources or portfolios. And we think it's important for South Carolina to have a say on what we're doing. I think about all of the conversation and concern that I've heard relative to offshore wind. If South Carolina, through this commission, is concerned about our pursuit of offshore wind, we have a way to deal with that. I mentioned that in my direct testimony, and Ms. Bateman mentioned it in her rebuttal testimony. So I think that's one of those types of things. I think when we exit this proceeding, knowing what the most reasonable and prudent plan was at the time it was reviewed, say the commission's order, I can't remember when the order's due, but say November 13th. I don't know what day of the week that is, but I'm just throwing that day out there as a example. I think what was the most reasonable and prudent plan to pursue as of November 13th should be given effect and meaning, whether markets change, whether there are tariffs, whether we have a recession, whether we see further tightening in supply chain. I think all of those types of things that happen on November 14th and after are certainly fair game, and we are held responsible in any case to how we execute on any of the activities in the plan. But as to what was the most prudent and reasonable plan for South Carolina customers, I think that we would look to the order to establish that, and 4 or 5 years later, if nothing's changed, I think it would be fundamentally unfair to 4 or 5 years later down the road for a party to say, you just did this because of North Carolina, or you just did this because of some other reason. I would expect that those types of issues would be resolved in this kind of docket. It's pretty reasonable, I think, as we're putting together a resource plan for the future of South Carolina. It's reasonable for us to understand who we're serving with the particular resources that we have in mind. So those are the types of things that I'm talking about, and I hope that's helpful.
It is very much. Thank you.
If I could just jump in as
Go ahead, Ms.
well
Bateman.
and add to that, that I agree with Ms. Smith, and I think I had particular concern when reading ORS's testimony and report that that this resource plan possibly could add incremental costs due to North Carolina law. Not definitively, not any particular resource pointed out, but possibly result in incremental costs. And to me, I hear that as, we should not pass any incremental costs due to North Carolina law onto South Carolina customers. And so I hear that as a red flag, that we don't need to wait until a rate case to determine if there are incremental costs in this portfolio due to North Carolina law, or if there's something that we should do differently if we were to ignore North Carolina law and only think about South Carolina law and policy. That I do think this is the right time to talk about that. And I know earlier in this proceeding, there was a question about, are we the only state in South Carolina that operates a dual state system? And we are. And we are the only, we're the only utility that operates a dual state system in South Carolina. We're the only utilities within the Duke Energy family that operate a dual state system. But we are not the only utilities across the country that operate a dual state or a multi-state system. And I know ORS witness Hyatt referenced Pacificorp. And so I can talk about them, but I can talk about, maybe provide some information about what other utilities that operate dual or multi-state systems do. So witness Hyatt referenced Pacificorp. And when I look at them, they developed a protocol, an allocation protocol. They call it an interjurisdictional allocation protocol. And it was basically, it's a protocol to allocate costs and resource benefits. It was developed through a multi-state workshop. It was filed with each of the states that they operate in. And as a reminder, they operate in one system across Utah, Oregon, Idaho, Washington, Wyoming, and California. So 6 different states, more complicated than our dual state system. So they developed this allocation protocol. They filed it with the state commissions, and it was approved by those state commissions, and they update it regularly. So that in that instance, the utility had clarity on the states that would participate in each resource in the plan, and they had a framework to direct assign both the costs and the benefits of those resources to that state. Southwest Electric Power Company is another utility that operates a multi-state system. They operate across Texas, Louisiana, and Arkansas. They, up until a few years ago, just like us, they had alignment in their states. They had one resource plan, and everybody participated. A couple of years ago, they filed in all 3 states for approval of certain wind and solar facilities prior to the construction of those facilities. And with that filing, they provided an option for a state to flex up, to either opt out or increase the load that they were going to take from those resources. So Arkansas took their normal allocation, Texas opted out, rejected the facilities, and Louisiana agreed to flex up or take Texas's share of the resources. And they developed a framework to direct assign the costs and benefits of those resources to the states that were participating. So again, clarity on the states that were participating and a framework for direct assigning costs and benefits. Appalachian Power is another state that operates a dual state system. They operate across Virginia and West Virginia. Virginia, a few years back, passed Virginia legislation called the Virginia Clean Economy Act, and it requires certain renewable resource additions. West Virginia doesn't have that same legislation. The Virginia legislation has a provision that if a utility operates a dual state system and the other state rejects a resource, that the utility can direct assign the costs and the benefits of that resource to its Virginia jurisdiction customers. So Appalachian Power has filed, now they're on their 3rd petition with the West Virginia Commission, and for various approval of various renewable resources. And so far, the West Virginia Commission has approved the first 2 petitions, and they have selected to participate in those resources. And some of the reasons include things that we've talked about in this proceeding: reduction in fuel volatility, reduction in fuel costs, renewable resource goals of their new and existing customers in West Virginia. So for those first 2, they opted to participate, and the 3rd one is still pending. But again, clarity on the states that are going to participate in the resources before significant commitments are made to those resources, and a framework for direct assigning the costs and the benefits. And so when I think about, this proceeding, and you've talked about what's different about this proceeding, what's different from me, from the chair that I sit in, is the ORS has raised that there could be incremental costs due to North Carolina law. And if there are, we should talk about that now and work on a framework to address that, rather than wait until the utility has actually constructed the resources and spent the money, and then talk about how there may be incremental costs due to North Carolina law.
Ms. Bateman, thank you. This IRP, the cost numbers are generic numbers. Would you agree with that?
Yes.
And I believe were you listening when Mr. Capps was testifying about the price of the generic cost of SMRs?
Yes.
And he indicated that between the company's initial IRP filing in August of 2023 and its supplemental filing in January of 2024, that those costs saw an extreme increase.
Yes.
If we're using generic numbers only, Ms. Bateman, how are we to determine in this proceeding whether there's cost incremental of anything?
I think you can, if there are costs that are being driven based on the assumptions that we're using here, based on the information that's known today. If we know today that there are costs being driven by North Carolina law, based on our current assumptions, we can know that. Now, those assumptions might change, circumstances will change. Of course, there will be changes, and the utility has a responsibility to act reasonably and prudently, responding to changes. But all we're saying is based on the assumptions in this IRP, and based on what we know today, is this the best portfolio for South Carolina customers based on South Carolina law only? Or are there incremental costs that are being driven by North Carolina law?
And I would say we don't think that there are. We think P3 fall base is the most reasonable and prudent plan for customers at this time, at the time it's being reviewed now. It is, you know, I know we keep going back to porridge. There are others who would have us do more renewables. There are others who would seek for us to achieve certain carbon reduction targets sooner. When I look at what we've proposed, it seems to line up straight down the middle of a variety of positions in this case. And so we do think that there are no incremental costs because P3 fall base is the right thing to do and the right way to go. But if the commission disagrees and says, and I just keep going back to offshore wind because that's what we've heard the most concern about, the commission believes that offshore wind is too risky and it's not in the interest of South Carolina customers to pursue that. That's really good feedback, number one, but it's also really good feedback for North Carolina because without South Carolina participation, the company may not pursue that resource. I think of the opposite being true on a resource like Bad Creek, where North Carolina is paying 80% of the cost. You know, without North Carolina, I don't think that's a resource that we could bring to bear for South Carolina customers. So, and that's why we proposed the methodology that I brought up in my direct and that Ms. Bateman brought up in her rebuttal, not because we want to go that route or because we believe it's in the best interest of South Carolina customers to go that route, but we also recognize that we're not the decision makers in terms of our what's in our resource plan, and we would really like to have guidance on that so that we can move forward and address the needs of South Carolina in a way that everyone can get behind.
Thanks. And Ms. Smith, based on your testimony, even though we are only dealing with generic numbers, the time for a party like ORS or any other intervener to challenge the company's decision to develop a nascent resource like offshore wind or SMRs is in this proceeding, and after that, they're stopped.
No, I don't think that's, I mean, I think there's a continuum. If the commission is interested in getting the information from what the ARFI yields and that would help the commission in future dockets, well, that's exactly what we asked for. We didn't ask to build offshore wind. We asked to pursue more pricing information through the ARFI. So, of course, it makes sense that the commission or even ORS wouldn't have that information until we brought it to bear, either in an update or the next IRP proceeding. But we also, you know, I get increasingly concerned because we keep, in my mind, talking about North Carolina more than South Carolina. And so when I think about that and the fact that we talk about North Carolina more than South Carolina in these proceedings, you know, I'd even done a word count at one point in testimony just to sort of challenge my thinking there, and I got a whole lot more North Carolinas than South Carolinas from ORS's filings. You know, if ORS thinks that our resource plan contains resources that would not be there but for 951, now is the time to let us know that, so that we can do something about it, including the path that Ms. Bateman and I laid out, or Mr. Hyatt described. I was pretty heartened by Mr. Hyatt's testimony that he had done work on for a number of multi-jurisdictional utilities. If he's got a way for us to help sort it out, I think we'd be more than happy to sit down and work through that. What we don't want to be, where we don't want to be, is in a rate case many, many years and hundreds of millions of dollars down the road, only to find out at the end of the road answers to questions that we could know today.
And with that, Ms. Smith, so if this commission approves an IRP that contains SMRs in the near-term action plan, are South Carolina ratepayers going to be on the hook for their share of $440 million?
I think that will be up to the commission in a rate case, but assuming that we reasonably and prudently incurred costs, I would think that those would be appropriate costs to bring forth for the commission. I think when we're in a rate case, when we look at prudency of assets that we bring to bear and that are serving customers at the time we file rate cases, part of the question around those resources is, did you do the right thing, and what were your other options? We have to investigate the other options to make sure that we are ultimately making the right decisions for our customers. So again, with that November 13th order date, again, that's not a real date, I just couldn't remember the date, but as of November 14th, the world could change, and we're absolutely on the hook for that. But I do think it's important that in considering South Carolina's energy future, that we're evaluating all of the options that make sense to evaluate for that future.
Ms. Smith, aren't we really talking about this last sentence here? That in North Carolina, Duke got the North Carolina Commission to agree to provide it some reasonable assurance of cost recovery, because otherwise Duke wouldn't pursue these resources Duke deems too risky to pursue.
I can't speak to this particular sentence, and I feel like you maybe just recaptured it in a way that wasn't intended. But what we're talking about is having a path for the future. If South Carolina does not want to invest in that path, and if South Carolina does not want to know whether offshore wind is a viable option or whether SMRs are a viable option and how much it could ultimately cost, now is the appropriate time to call us off so that we have that information.
Thank you, ladies. I appreciate it. No more questions.
Thank you, Mr. Torrey. We're going to, before we start commissioner questions, we're going to take a short break, if that's okay. It's 4:15. If we could be back in about, I don't know, 15 minutes, 4:30. You ladies are under oath. Good afternoon. We're back on the record in the Duke Energy's 2023 IRP docket. We are now at the point of commissioner questions of the final panel as presented by Duke Energy. Commissioner Belser.
Thank you, Mr. Chairman. Good afternoon, ladies. Thank you for being here.
Good
Not
afternoon.
that you really had a choice, but thank you anyway. Ms. Bateman, you probably have anticipated a question that I may ask, but are you able to provide a little bit of background on the dual state operations? And my recollection kind of goes back to the joint dispatch agreement. And could you explain what that is, and how it operates?
Yes. So the joint dispatch agreement, it was approved as part of the merger of Progress Energy and Duke Energy. So when those two holding companies merged, we had proposed a joint dispatch agreement whereby we would dispatch between the Duke Energy Progress and Duke Energy Carolinas utilities, that we would jointly dispatch those two utility systems. And this commission approved that joint dispatch agreement. And so I'll try to explain it as a non-engineer, but there are efficiencies that you gain when you dispatch across a larger system. And so, for example, when Duke Energy Progress has met all of its demand on its system, and that next resource that could be dispatched is less expensive than in terms of variable cost, the next resource that needs to be dispatched on the Duke Energy Carolinas system, that energy can be transferred. You can dispatch the Duke Energy Progress resource to serve the Duke Energy Carolinas load. And that savings, that difference between those two variable costs of those two resources at the top of each utility's dispatch stack, that is the savings.
And that works both ways.
Yes,
right?
yes, it can go either
if
way.
If DEC needs the power, they can get it from DEP. If DEP needs the power, they can get it from DEC.
Absolutely.
Okay. And go ahead.
I was just going to note that joint dispatch agreement, just to give a magnitude of dollars, that since the time of the merger, that's provided over $1 billion of savings to the combined system customers.
And at the time, and I'm going by a lot by recollection here, but at the time that that merger occurred, there were some almost immediate savings that got flowed back to customers. Is that correct?
Yes.
And those have since gone away, but that did happen at the time. For a few years following the merger.
So are you talking about the fuel savings? Because
there were some credits, I thought, that kind of got flowed back through the bills.
On the transmission mitigation, but also just on savings. We had combined.
That may have been.
Yeah, we had. If you think about things like SEC reporting, there were consolidation of those kinds of functions. There were consolidations of duplicative functions that were held by two different corporate entities that were no longer necessary. So those savings started, flowing back with rate cases around that time.
And but the commission approved at that time. The South Carolina Public Service Commission approved this sharing, or the systems being operated together. Is that correct?
Yes.
And prior to the merger, there was still dual state.
Yes.
For DEC had a dual state system, and the old Progress had a dual state system. Is that correct?
That is correct.
And that had occurred, I don't know how many years ago. Predated me for sure.
I think it's over a century for both utilities.
Okay. I appreciate those clarifications. And part of the joint dispatch agreement there were a number of regulatory conditions that were adopted. Is that correct?
That is correct.
As well as reporting requirements.
Yes.
And I believe also cost allocation.
Yes, in terms of the sharing for the
sharing?
joint, yes.
And periodically, there has been an updated cost allocation manual that's been filed pursuant to the merger. Well, it really wasn't called a merger here. It was called more the joint dispatch agreement, wasn't it?
Yes,
There's not a merger order.
that's correct.
Okay.
But we do file a cost allocation manual, I believe annually with this commission. I know we've filed two types of cost allocation manuals, but one of them is how we allocate the service company costs to the utilities. And so we file that. And then we also, from time to time, file a cost of service allocation manual. That may be more in rate cases.
And that's where kind of this idea of the 80-20, 75-25 allocation of expenses comes from, is it not?
Yes, the cost of service, yes.
And that's based on sales or kilowatt?
So there's a few components. So for generation or production resources, we usually break it up into demand and energy.
Okay.
And so the energy, you think about your variable costs, mostly fuel, is allocated basically on sales or energy produced at the generator. And then the capacity cost, you think about the cost of the plants, your fixed costs, we allocate based on contribution to peak demand. And that can be, I believe in our most recent rate cases, we proposed using what we call a 12 CP. And so that's your, each jurisdiction's contribution to the peak and the average of the 12 months. So the system peak for each month, the sum of those.
Okay. I want to talk a little bit, and this probably may be more for Ms. Smith, but Ms. Bateman, if you need to jump in, let me know. Ms. Smith, do you happen to have a copy of the IRP statute with you?
I have a copy of the balancing factors. I do have a copy of the whole statute. Hold on.
Well, I'm looking at, and it's below the balancing factors, actually. I'm looking at 583740 C4, which is right below the balancing factors. Thank you, Mr. This is how tired I am. I just drew a blank on your name, Mr. Weldon. Sorry.
All right, I think I'm there.
Okay. So one says the submission and review and acceptance of an integrated resource plan by the commission.
Yes.
Okay. And I'm just going to finish reading that. Or the inclusion of any specific resource or experience in an accepted integrated resource plan shall not be determinative of the reasonableness or prudence of the acquisition or construction of any resource or the making of any expenditures. Did I read that correctly?
Yes.
And then that section finishes, an electrical utility shall retain the burden of proof to show that all of its investments and expenditures are reasonable and prudent when seeking cost recovery and rates. Did I read that correctly?
Yes.
So given that statute, this commission, am I correct that this commission cannot pre-approve cost?
That's correct.
Or the, cannot pre-approve cost?
Cannot approve costs.
Okay. Or cannot, what is decided in an IRP does not approve the specific building of any plant. Is that correct?
Correct.
Okay. So let's talk about the near-term action plan. And I should have gone back and looked at this, but in Duke's prior IRP, and I think when we went through this before with the comprehensive, DEC filed one and DEP filed one. Is that correct?
That's my recollection.
I'm getting DEC, DEP, and Dominion mixed up. But in somebody's, the first time we had to approve the comprehensive, this commission required one of the utilities to include a short-term action plan, is what we called it. Was that Duke or was that Dominion? Do you recall?
I believe it was us.
Okay. I think it might have been everybody. And that is not necessarily covered in the IRP statute, is that correct? Or do you know?
It's not called out by name.
Okay.
You will not find a subsection of the IRP statute that references a short-term action plan or a near-term action plan. But I think it's inherent of the concept of having a 15-year plan. So years 1 through 15, it's logical that those near-term years will have actions and activities associated with them. I think that's also called out, not specifically, but it makes sense when harmonized with the balancing factors, because that is showing those activities or how you demonstrate that, for example, that resource adequacy and capacity can be met and therefore balanced, and that you can have some visibility on what costs may be so that consumer affordability and least costs can be met and therefore balanced. Same thing for reliability, commodity price risks, diversity of generation supply. Diversity of generation supply necessarily contemplates different types of generation. So I don't think you can get to these factors without looking at them for the entire IRP, but certainly in the near-term years, that specificity, I believe, is necessary to balance A through G, in my mind at least.
And without some sort of path forward, is it really a plan?
That's exactly right. That's exactly right, Commissioner. I think it's, what's the saying? A goal without a plan is just a wish. And so we just want to make sure that we're all starting from the same spot and that we understand the direction that we're moving in. So plans are plans, and I suspect that the next time we file a comprehensive IRP, I'll be surprised if something in the universe hasn't changed, and our plan would need to change along with it. So I think what we're looking for is, are we all at the same place on the starting line?
Okay. Now, I think in your testimony, I had written down a blurb that the near-term action plan should serve as a guide for its generation and transmission planning. Does that sound familiar to you?
Yes.
Can you, and you may have just done it, but can you tell me what that means to you?
Sure. I mean, and when I think about this very much in terms of the subsection that we just talked about, where IRPs are not determinative. I don't think IRPs are determinative, but I do think they are informative. We think of them as probative, because having a plan gives us something to work to or depart from if the circumstances require it. But having a plan and knowing what our next steps are for the near term and the long term, those are the actions and activities of how we meet all of the balancing factors so that we can bring it forth for y'all to consider. So when I look at A through G, every single one of those balancing factors contemplates the type of specificity that we have included in our plan. And it is natural that the near-term years would have more specificity than the longer-term portion of that 15-year period.
Okay. Now, am I correct that North Carolina requires an IRP every 2 years?
That's correct.
And the South Carolina statute just says at least every 3 years.
That's correct.
Is there any thought with doing the comprehensive every 2 years? I'm not trying to add cost, but I'm just wondering going forward.
I sure hope that Mr. Schneider is not still in the audience.
But you're doing it anyway.
But if he is, it may make sense to have this party every 2 years, so we can continue having these conversations. I don't think we've been shy about seeking time with the commission appropriately. In this hearing, wanting to have as much time with y'all as possible. And wanting to share as much information as we can. The future is uncertain. Commissioner Williams asked what had changed. And I mean, as I've thought a lot about that, I think what has some of the things that have changed is maybe our ask isn't different than other utilities, but I think our need might be. So we've got a 40,000 megawatt system. It's a big system and it's got big needs. And so we are really looking in this, on all IRPs, but particularly on this IRP where we are looking at an energy future that contains a lot of different resources, driven a lot because our system is so big and our growth has been so accelerated, and so many companies are locating in South Carolina and bringing jobs and supply chain with them. That is a very big thing that has changed. At the same time, we have had more opportunities and challenges from that growth. We have become concerned about perhaps getting a clear line of sight on understanding what South Carolina wants from Duke Energy. And so, you know, I go back to the activity for stakeholder engagement in this docket. We had a very robust stakeholder engagement set of activities in this docket. And it would be really helpful going forward if the folks who've participated in these types of dockets are at the table in those stakeholder engagement sessions. We get a lot of work done there. We get a lot of ideas that we wouldn't have otherwise. We resolve a lot of challenges that we wouldn't have otherwise. I think, you know, the statute calls for other parties to bring forth alternatives if they have them, or alternative plans. I think one of the reasons that we didn't see that in this case, although certainly there are, you know, sort of isolated issues that parties are interested in, is because we did that legwork. So getting the right starting point, having that engagement in between IRPs, coming to y'all with annual updates and comprehensive IRPs. I know there has been some scheduling activity, I think, from the clerk, because y'all are very busy, and I know there's been some activity, I believe. Mr. Welburn would know it better at looking at schedules in out years for these types of proceedings. We think that, you know, we'd like to come back no later than 3 years from the August filing that we made in this case. We're not looking to come back later as a result of the extended time frame in this case. So I hope I answered your question.
I think you did. Thank you. I want to talk a little bit about how this IRP process works with some of our other. And it's really coming back to this Section 40C4 again. Let's talk about siting. Just because, let's say hypothetically, Commission approves this plan, approves the near-term action plan, and then Duke comes in for, let's use as an example the combined cycle plant in South Carolina, comes in to get that sited. And there are a number of factors that the company has to show in a siting case. Is that correct?
Yes.
Okay. Is Duke going to come in here and say, well, it was in our IRP and it was in our near-term action plan, therefore we want it cited? Is that sufficient?
We've got a lot longer laundry list in the Siting Act case. So I think it would be difficult for us to pop in a Siting Act proceeding not having something in the IRP, but we would definitely reference the IRP in a Siting Act case. But we also have to deal with, let me get my words right. We have the opportunity to work through environmental processes, local engagement, that kind of thing in a Siting Act process. We also have to show a comparison of other generation options, and I think what that might look like depends upon what the resources are at that time and what our opportunities. I think that'll be probably something specific to each case, but they are a hefty lift. We did do a Siting Act case recently for the Robinson Solar.
Let's be careful there because the order's not out yet.
then I will say the last CC that we put forth was, gosh, it was in the early teens, if I remember correctly. So it's been a while since we've had a gas plant sited in South Carolina. So there is a long laundry list of things over and above the IRP that we're required to bring forth in a siting act case.
Well, and I can understand that the code needs to work together. However, I just am looking that there is a lot more in a citing case than just saying it's in the IRP.
Yes,
Okay.
that is correct.
And Duke recognizes that, correct?
Yes, and I think it goes both ways. So, for example, I look at Bad Creek. Bad Creek is a big asset, a big potential for the Carolinas. Our plans are to bring a Siting Act application to this commission in 2025. That's part of a long continuum of continued evaluation, firmer cost estimates. We come to this commission. There's further FERC activity. I mean, there's a whole continuum of activity there. But if our continued evaluations indicate that something's different than what we think today, and it's no longer a good option for South Carolina customers, then we wouldn't come bring a Siting Act application just because it was in our IRP. I expect we would have to explain why we didn't pursue it. But I think we agree with the Office of Regulatory staff that the burden of business decisions lie with the company, and that we have additional requirements when we bring forth assets to build. But it will be informed by this proceeding, by what comes out of this proceeding.
And that's just the siting of new construction subject that meets the requirements of the Siting Act. But then that doesn't even guarantee the cost recovery.
No, it doesn't.
That comes up in a rate case, is that correct?
That is correct. And we're in a little bit of a donut hole when I look at Georgia and North Carolina. I mean, some other states around us have cost recovery built into their certificates. South Carolina does not have that, and we're very aware of that. And so when we come forth in a rate case, in an IRP, we plan the thing. In a Siting Act, we get permission to move forward with the thing. But in a rate case, we have to answer for how we did the thing. Did we execute prudently? Did we look for cost savings? Did we spend the right amount of money? What were our other options? What did we know or should have known? Those are the types of things that I frequently see come up in rate cases.
Am I missing something on the process of how this works? The IRP, then possible siting, then cost recovery after that? Am I
No.
missing something? There are a lot of big numbers in the IRP, or estimates, let's put it that way, estimated numbers. And as I've been going through all this, I've just kind of thought about this. Has there been any thought of requesting potential securitization of some of these costs when it gets to it versus coming in through a base rate case? Just curious. If you can't answer that, I understand that too.
Yeah, no, I think of that in terms of storm.
Well, that's the way it is now. I mean,
Right,
legislation would have to be.
Yeah, it would require legislation, and I also, think that we have a business model that has worked very well, and we think will continue to work very well. So I don't know if you have any
I
thoughts
just didn't
on-
know if if there might be any thoughts on that.
Yeah.
It's certainly not anything that's on the radar right now.
I get, but what is on the radar is those are big dollars, and we are looking at big dollars in the future, and there's no way, and we're not trying to evade that fact, but they are spread over 4.6 million customers, and so the cost we have a very large customer base to spread those costs over. And then we're doing a lot. We've talked a lot about how much we could spend. We also talk a lot in our IRP about how much we can save with between IRA monies, things like investment tax credits, production tax credits, citing things in a way that maximizes that value. We're also making the most of what we have in terms of extending nuclear plant lives. Those are assets that it makes sense to extend their lives. So we're looking at extending the lives of all of our nuclear plants. There's a process for that, and Oconee was up first. But we have a section in our IRP that talks about that because we want to make sure that we get all the benefit of those units that we can for customers. We also, as I think about it, have a lot of investment in mind in energy efficiency and those grid edge technologies that Mr. Duff talked about. We deal with programs more outside of the IRP, but we have extremely aggressive goals. I think the phrase that we've been using is shrinking the challenge of the future, but that, number one, helps shrink the need that we would otherwise have for additional resources. But those are also the same kinds of programs that will help with rate impacts as we move through time. And we've, in general, for every dollar we spend on energy efficiency, we're able to bring back around $5 of benefit for customers. So there are big costs, but there are also big savings opportunities, and again, spread over 4.6 million customers. But I do want to say, when we started this case, it was around a little under 4.5 million customers. We're already at something like 4.675 million customers. We've grown a lot just since we filed this case. I think we have even, maybe around 30,000 more customers just in the state of South Carolina. The states are growing proportionately, as Mr. Stillman said. So we've continued to have those changes even since we filed, which also contributes to our needs, but it also contributes to the solutions for those needs because it's more customers to spread those costs over in rate proceedings.
Thank you. Thank you both. Mr. Chairman, that's all I have.
Thank you. Vice Chair Williams.
Thank you, Mr. Chair. Good afternoon, ladies.
Good afternoon.
I guess, I don't know how long the chair is going to have us here. Soon it'll be evening. Did you have your Snicker bars? I had mine. Make sure I didn't have an attack. You all have done a great job with the IRP. It's comprehensive. You can tell you put a lot of time and effort into it. So I just want to acknowledge that. You've done a very, very good job. What stands out to me more than anything, and I think you probably sort of know this based on some of the questions that I've asked, considering that this commission, the current commissioners, heard the first IRPs to be filed for approval with this commission, it stands out to me that the company's posture has changed somewhat. Could you explain how and why the company's posture before the commission regarding this IRP has changed?
Compared to the
Yes,
last
ma'am.
one.
Yes, ma'am.
Do you want to start?
I'll be happy to. What hasn't changed is we have been talking about retiring coal plants for a long time. We have had healthy growth in South Carolina, but not necessarily exceptional when you look at our region, which is a high growth region. We had a series of IRPs that weren't litigated, but Duke Energy did a fair amount of engagement with them from a dual state perspective. But the urgency of our need has changed, and I would say one of the things that has also changed is this commission's guidance to us. We got homework out of our last IRP order, and that, I'm paraphrasing, but we took this very seriously. I am contemplating getting a pillow with it embroidered on it because I woke up thinking about this sentence for so much of the last couple of years. And that was, that, you know, if for a dual state system, at times there will be regulatory structures and paradigms that will align, but where there's not alignment, a dual state system needs to accommodate those differences. And so I think that's one of the differences that you have seen because we never had a South Carolina chapter before. And so I felt, and we all felt it was very important to put that forth. We'd never done that before. We also had never really contemplated that there could be a world where such accommodation might be specifically necessary just because we hadn't been in that situation before. So Ms. Bateman and I were part of a very in-depth effort on that latter part of the equation on accommodating differences. And so we looked at some of these other multi-state utilities to develop a proposal so that if South Carolina, through y'all, didn't agree with our vision of the energy future for South Carolina, that we could have a way to deal with that. If there were a particular set of resources that a party felt were called for by another state or were not in South Carolina's interest, we have a lot of thoughts about how to take care of that through cost allocation of costs and benefits and how to deal with that in rate cases. So that's another thing that changed. I think the other thing that changed for us was getting really concerned about hearing so much about North Carolina as if there was no possibility for us to be on the same path from different entry points. Coming from Greenville, I take 385 to 26 to get here. I normally take Butler Road, if anybody lives in the upstate, I normally take Butler Road to 385 to 26. That's how I get here. I've got my QT, I've got my Bojangles I like to stop at. I go there I go that way most of the time. I was late to use the app Waze. So I think the world found out about it before I did, but I encountered a lot of traffic. I encountered some trouble. So I punched in I was coming here actually, the commission's address in Waze, and it took me down Fairview Road, which is a way I would have never gone. It took me a completely different way. I had no faith in where I was going. It just wasn't a route that I had taken before. But out I popped on 385 going the same direction, the same destination, but I took a different path. And so it actually saved me a couple minutes. But when I think about our dual state system, I think that we can wind up at the same path even if we get there from different entry points, which is, I think, what our arguments have been about. So we looked really hard for those opportunities. I'm not sure that we could sit here. I'm not sure that I could sit here with South Carolina in my job title and have the same view of maybe P1 or P2. But when I look at P3 and where it puts us in terms of emissions reductions, out in the 2035 time frame, we've blown past the 2030 goals of 951. So I got really concerned that there would be so much focus on what North Carolina said versus are we winding up at a place that makes sense for both states, looking at it individually through the lens of both states. And so you see us put a lot more attention to that, and we're getting a lot of questions about it. So I think the other thing that's changed is investors are very interested in our IRPs. We get a lot of questions about the resources in our IRPs. I didn't used to sit down and talk to economic development prospects. I wasn't the kind of resource they really had on their radars. But now I'm going and sitting down with a lot of economic development prospects and current customers because they're making their plans. They want to know what's going to be serving them, or to the best of our ability, what can we tell them about our generation mix, because they're making decisions on the generation mix that's going to serve them. So I think the combination of those factors has changed the urgency of what we're asking for as well as the growth. And it's changed how we maybe package things. But at the end of the day, I think our ask is still the same as other utilities looking for that guidance on on the steps we're taking to South Carolina's energy future. I hope I answered your question.
You did. We're getting there. I appreciate your full answer. Just to help guide us here, what I'm focused on now is the IRP statute 583740 C2G, and I'll read it as other foreseeable conditions that the commission determines to be for the public's interest. It's balancing factors. I think you all refer to them as balancing factors. And so, bear with me here a little bit. Indulge me. I have a little bit of trauma, being the only commissioner who sat through the merger and abandonment case, where I still remember the opening statement from the company. Success has many fathers, but failure is an orphan. And so we know what happened in that case. We know how we got there and how the BLRA has been repealed and so forth and so on. So anything that smells anything like, looks anything like, feels anything like, tastes anything like a pre-approval is somewhat triggering. Not that because it won't work. I mean, what you all have put forth, it may work perfectly. In the event that it works, no one really will say much about it. But if it doesn't work for some reason or another, if there are cost overruns or just some catastrophic event that causes South Carolina ratepayers to be on the hook for catastrophic costs, that someone will say at that time, if it happens, that we, those of us sitting up here, should have known better, and we should not have given you the guidance that you're requesting, and we should have just stuck to the law that simply says that IRP shall not be determinative. You know the rest. How would you respond to that, considering what has happened here in South Carolina by way of real costs that are being paid now by ratepayers, not in your service territory, but by ratepayers who are on the hook for a utility, a nuclear facility, unit, I guess 3 and 4, maybe just 3, that never went into service. And now you all are here with seeking guidance for SMRs and onshore wind, possibly offshore wind, and so forth and so on. And I know, and this is a long question, but I want to give you everything so you can just respond to it one time. And I know the Office of Regulatory Staff is here and they represent the public interest, but the consumer advocate doesn't have to intervene in these proceedings. And we know that the consumer advocate represents the average residential ratepayer. They may not, their value stack for where economic development comes in to play may be different than the Office of Regulatory Staff. And I appreciate everything you all are doing for economic development because that's important. But what's also important to a family of 5 trying to survive in your service territory is minimizing the amount of money that is coming out of their household for all bills, utility bills included. How would you all respond to that?
I may take it since I was around and living in South Carolina, and I certainly, that wasn't a Duke Energy case, but I think a lot of us in South Carolina certainly felt the sunburn, maybe not the blister, but the burn from that event. And so when I think about what transpired and the motivating factors of Act 62, which included avoiding that type of scenario in the future, I believe that's one of the things that the IRP is designed to prevent. When that project was under construction, there was not a robust IRP process like there is now. I think the Act 62, I counted it at one point, but it added like 1,000 words to the IRP statute, added a lot of what the companies need to file, what the commission needs to review, gave a lot of direction as to how the commission should be making decisions. It gave a lot of authority to the commission, and when I look at not determinative of future cost recovery, I see that as a limiter to that authority, but I still think that authority exists on IRP plans. And the fact that we have annual filings and annual updates, I mean, there is a continuous stream of information coming to the commission that I believe was enacted in response to the situation that you described. I think these are hard choices. They are hard choices, but you know, if SMRs comes out, what goes in its place? If offshore wind comes out, what goes in its place? I think those are the other side of that equation in putting a plan together. So I think it's the onus is on the company to take reasonable and prudent actions, but also to be transparent about them. And when I think of the family of 5, I think about my little family of 4, because my kids going to school in Greenville, South Carolina, have opportunities that I did not have when I was growing up in the late 70s and early 80s. They simply have opportunities that I did not have. And so I want to make sure that we have competitive rates, but I also want to make sure that we're doing our part for the state's future. So I think our plan answers that. But then I also, going back to that family of 5, I think that's why the types of programs that Commissioner Williams has been asking about are so important for affordability. And I think it's really a part of our obligation to bring forth what we think is the best thing to do, what is the best direction to move in, and then understanding where the commission agrees or doesn't agree.
And if I could add a few points to that, agree with everything that my co-panelist just said. In terms of, well, there's a couple things I wanted to hit. So I believe this commission approves, modifies, or rejects the plan as the most reasonable portfolio based on the information at the time. So obviously there's a lot of, for resources in the out years, there's a lot that's still not known. And so you make the decision based on the information known at the time. We will gain more information as we pursue and explore these resources. And we'll update the commission with that information in our filings. In terms of the family of 5, I do think about that. And so we've talked about cost, and that is one of the balancing factors, the affordability and least cost planning. And this has been brought up before by the prior panel, but the commodity price risk. And so there's a cost of the portfolio, and typically we measure that in present value of the revenue requirements. And if you compare P3 to P0, and I know no one's recommending P0, but just as a comparison, if you compare P3 to P0, the revenue requirements through 2038, it's about 5% more expensive. P3 is. However, if you look at the fuel makeup, P0 has over 50% of the energy from natural gas, whereas P3 has 25%. And you think about that fuel volatility. And I'm very cognizant of what that can mean for customers. I know just 2 years ago, we filed for double-digit increases in our fuel proceeding. And that was hard, and it impacted customers. We ended up reaching a settlement in that case to spread the recovery out over a longer period. Unfortunately, this year, we filed for double-digit decreases in our fuel proceeding. And so that kind of volatility impacts customers too. And so I'll just bring that up, that there's kind of the cost of the portfolio, but then the impact on customer bills of the volatility as well. And so I think the balancing factors have this commission balanced. That's why there are these balancing factors. There's affordability, but there's also commodity price risk, diversity of generation. a lot of factors to balance. So that I would say that on that. In terms of, I do want to talk about what happens or how would we handle this if South Carolina were to choose not to participate in a generation resource. And I don't even think we're, at that point in this proceeding, but if in the future, let's say we get information back on offshore wind and North Carolina wants to pursue it and South Carolina doesn't, I wanted to take a few minutes to just talk about what that might look like. Because I mentioned it briefly in my testimony, but I don't give a lot of details on it. So if South Carolina were to opt out and North Carolina were to continue to pursue it, we would build the resource, we would direct assign 100% of the cost of that resource to North Carolina. So South Carolina wouldn't pay any of the costs of that offshore wind facility. However, the energy and capacity coming out of that offshore wind facility would go directly to North Carolina. And so the North Carolina load served by that generation facility would be removed when calculating the allocation factors for the rest of the system. And so the effect would be that North Carolina would pay 100% of the offshore wind facility. They would pay a slightly lower percentage of the rest of the system because they would be getting less energy from the rest of the system. And South Carolina would pay none of the offshore wind facility, but a slightly higher percentage of the rest of the system. And that's just one way to do it. That is, I talk about that as an average cost framework, but that's one way to do it. Obviously, we'd have to put some limits on that, how much you could opt out of. You couldn't opt out of all new generation resources before having to build something specific to South Carolina. But I do think there is a framework that could be developed to that is fair and equitable to both states if there is a difference on which resources the states want to include in their portfolios. And I'll bring that back to the portion of the Commission's order in 2022 that Ms. Smith referenced, that where it's incumbent upon the utility to recognize that North Carolina and South Carolina have different statutory structures, which at times align in other instances. However, due to specific regulatory requirements unique to a single state, dual state planning must accommodate those differences. So I think about that as a difference in this IRP proceeding from my perspective, that, seeing this order in 2022 and understanding that we need to try to accommodate differences in the planning process, we worked on developing this framework.
Just before we leave, back to that family of five, I also think about our rates being lower than the national average. We get kind of mixed up, even myself, I get mixed up between rates and bills. So our rates continue to be lower than the national average and very competitive and lower than a lot of the Southeast. Now, that's going to be at any given time because other companies are raising and sometimes lowering rates as they go. But we've consistently, when I think about, when we looked at this as a snapshot, as an annual snapshot earlier in the year, we were 18% below the national average for rates in South Carolina as a state, and Duke in particular, like Duke Energy Carolinas, was 22% below the national average, and Duke Energy Progress was 14% below the national average. So both of those are good deltas from the national average to where our rates are, but we can see high bills based on usage at those lower than the national average rates. Some of that is from housing stock. If you think about how much of our customer base might be in perhaps maybe manufactured homes or homes without maybe the best windows or that kind of thing, which is where a lot of our weatherization programs come in, where we can help customers take care of some of those programs, and where those programs can't, Duke Energy employees do a lot in the community, whether it's picking up a hammer and working on those weatherization projects, or through donations and through our Share the Light type of activities. So we're really proud of where our rates stack up. That's not something we're looking to change or lose. I do think that some of the rate information that has been put forth it does create a little bit of sticker shock. And one of the things that I had not really appreciated going through this process, and Ms. Bateman can speak to it a lot more eloquently than I can, but all of those numbers are inflation adjusted. So if you look at the today dollar, if you put it to apples and apples of today's dollars, that actual impact is a lot less. And I don't know if you want to, I think it's like 2.5% inflation assumed in there. But I think that would be, I didn't realize that until a certain point in the process. And I think that's helpful information.
Yeah, so the modeling team has included an assumption of cost escalation at 2.5%. And so if you think about that, the cost of anything that you buy in the 15 years from now is going to be more expensive than what you can buy it at today. There'll be some normal impacts of inflation. And so we've done some calculations to adjust, and our rate impacts that we've provided are nominal. They don't account for that inflation or adjust for it, so they're not real dollars. But once you adjust for that, the impact in 2038 on the typical customer bill is about $15 to $20. And so there's some amount that the cost of everything's going to go up by, and then P3 fall base would impose an additional $10 to $20 on the typical residential bill.
In 2038.
In 2038, exactly. 15 years from now.
Thank you. So I want to be clear about something. You all have been very transparent, in this case, at least from my perspective. A lot of questions I wouldn't have if you were not so transparent. So I appreciate that. When you talk about opting out, how would the commission opt out, or what would that look like for us to say, oh, we don't want offshore wind? Mm-hmm. I don't think we've ever done that before.
Yes, and so I give that example of SWEPCO with Texas had never done that either. And so they had, for the first time, they had divergence in their resources. And so I do think we should have more stakeholder engagement to flesh out the framework and possibly file a proposal once we've done that stakeholder engagement with this commission and the North Carolina Commission. So I do think there's more work to do before we have a formal proposal for this commission. But the way that I see it, I think it's probably premature now if we're thinking about offshore wind or SMRs. But I would think it could be at the Siting Act, and I know it's complicated because if the facility is located in North Carolina, there's not a comparable filing in South Carolina that's required, but there could be. There's nothing that, if we developed a framework and this commission approved it, that required a filing, that could be a time to do it.
Well, let me be clear. I'm not making any suggestions. Yeah. I feel very uncomfortable telling you what not to pursue.
Yeah.
Because obviously someone's going to have to pay the price if the lights go out. Mm-hmm. I'm just, it's just, to me, it's almost a different framework to pursue, to take that approach.
Yeah, and I do want to be clear because you mentioned the lights going out. We have an obligation to serve our customers. We would ensure that we would reliably serve our customers. It's just how we would do it. And so if South Carolina didn't want to participate in the offshore wind, South Carolina would receive power from a greater percentage of the rest of the resources in the portfolio. We would still build to serve the system. It's just how those resources divvy up between North Carolina and South Carolina could be different if there's a divergence in the state's preferences or regulatory requirements.
And just so I'm clear, regardless of what we do with this IRP, are you telling me that would or would not impact? Let's say we rejected it. Mm-hmm. How would you interpret that rejection? Would you interpret that as South Carolina doesn't want to pursue offshore wind or SMRs?
So I might need some help from my co-panelist in terms of, if you reject it, is there modification? Is there direction on, something else to file?
I would say on that particular resource, there's another portfolio that's in the IRP that Mr. Quinto mentioned where we had run a portfolio without offshore wind. So I think that is one path. I mean, it is something different, and so that's one of the reasons I was so heartened when I heard Mr. Hyatt give testimony about seeing other utilities grapple with this type of situation, where there had been discussions among stakeholders and an allocation reached to and proposed to respective commissions.
So before you go on, excuse me for interrupting you, but also I want to approach both options simultaneously. If we accept it or adopt it or approve it, whatever term fits your fancy, does that mean full steam ahead?
No, it means when we go to the near-term action plan, it means exactly what it says in the near-term action plan, because sometimes when this makes my heart flutter a little bit, because we're talking about really big decisions and really big technologies, my home base is what did we actually ask for? And so when I look at offshore wind, for example, what did we ask for? We asked in our plan to make sure that we get guidance that pursuing an acquisition request for information is the right activity to pursue, and that conducting stakeholder engagement and outreach in connection with that request for information, and report that information into this commission and the North Carolina Commission, and continue limited development of onshore wind transmission to support offshore wind. And so those are, I think of those as baby steps, and that we're holding ourselves accountable to coming back to the commission and seeing where that lands and seeing what that feels like. So when we're looking at this, we're looking at what's the most reasonable and prudent plan at the time it is reviewed. And for us, that includes offshore wind, but the activities to validate that and scope that are what's included in our near-term action plan. When I look at something a lot more near-term, when I look at bringing forth something like a Siting Act application next year, getting approval of the South Carolina CC activities is not approval of the South Carolina permission. It is approval to continue the activities that would move us toward a Siting Act application. But if that's not the path we want to go down, we would just like to be called off, so that because we're going to have to figure out something else to do. But I think also, when we're in a dual state system, it's helpful. Both ways, because if South Carolina ultimately decides, maybe in the future, upon more information, that offshore wind isn't the way to go, well, I don't know that North Carolina would pursue it if South Carolina wasn't in the boat with them. And so, I hate to speak so plainly, but that's kind of what we're dealing with. And when I come back and look at the actual activities, this is all the stuff that prudence is made of, where we are evaluating and gathering more information on the things that are longer term, and making sure in the shorter term that we're getting those resources on the system that can start producing those kilowatts.
I got you. My last comment, and you're welcome to respond. But really, just talking through this with you, it seems as if what the company has tried to do is be somewhat deferential to the commission by giving them what they think is the best option, but not closing the door on other options.
That's exactly right, Vice Chair.
I want you to talk to my wife. I would like to hear that more often. Thank you very much. That's all I have, Mr. Chair.
Thank you, Vice Chair. Before I turn it over to Commissioner Caston, I just have a couple of questions. I want to ask them before I forget my train of thought. Both you, Ms. Bateman, and you, Ms. Smith, you have a tough job when you're dealing with two different sets of rules and trying to play the same game. it's really kind of a tough situation, and I feel for you on that. But I mean, there's no question. We do not have carbon neutrality in South Carolina, or dealing with the same things that you're dealing with in North Carolina. No question about that, is there?
There is no question that we do not have a bill like 951. That is an undisputable fact, that we do not have a carbon reduction explicit goal codified in law.
Well, and you mentioned legislative intent, but until there's a law, I don't know that we can really interpret what the legislative intent is to do that. But it seems like you put a lot of work into it. One of the questions I have, and I only have a couple, is in your direct testimony, you talked about should North Carolina or South, on page 48, should North Carolina or South Carolina choose not to participate in one or more of the generation units in the RP, such as the wind, there's potential that both the cost and benefit from those units will be assigned only to the customers in the other state. And there's been similar pronouncements, I felt like, in the Robinson case and the CPRE. Can you kind of unpack for Commission just how that would work, how you could use one resource and withhold it from the other, how that would work? I just can't.
Sure. Let me take a stab at it, and then I know Ms. Bateman will correct me or give me the better words. But I just want to sort of pull back at 10,000 feet.
Yeah.
What does that look like?
Yeah. One thing is I've noticed when one of you said something, the other one always agreed with them.
We spend a lot of time together. We spend but we spent years talking about these issues. Talking about these issues in preparation of sitting before you today.
My first thing is, does that question make sense?
It does.
Okay.
It does. And so, for example, if there is a resource that this commission believes is motivated by North Carolina law or not in the interest of South Carolina customers, then the cost of that resource, say it's $100, the cost of that resource would be direct assigned, that $100 direct cost that would be assigned to the other state. And so we would handle that through the cost allocation process, rate cases, et cetera. But say that $100 resource is a renewable resource. Well, that renewable resource doesn't have any fuel cost associated with it. So we would have to take that benefit, the benefit of that $100 resource, say, but for that resource, a fuel rate might have been $2 higher. We'd have to get that $2 benefit and also assign that to the state that paid for it. And so that's what we mean with cost and benefits. If it's a renewable resource, the RECs would follow too. Now, we would operate the system in the way that makes sense for the system, but these would be adjustments to our dispatch and our cost to make sure that the costs and benefits follow to the state that wanted them. And you can clean me up there, I think.
No, you said it perfectly. But I do want to add, and I tried to probably not very well explain that a little bit ago with this average cost allocation. And so in this example, if there's a resource where the costs and benefits are direct assigned to North Carolina, it doesn't mean that we're not going to serve South Carolina. Obviously, we're gonna meet the needs of our customers in both states. But if that resource is direct assigned to North Carolina, the load, the capacity from that resource would go to North Carolina. So if any fuel savings would go to North Carolina, and then South Carolina would get a greater share of the rest of the resources in the plan. And so let's say the rest of the resources might include more natural gas. They might include, and all of the other resources that we're adding. But it would give a slightly higher percentage of natural gas to South Carolina, so there'd be a little bit more fuel price volatility. The carbon intensity would be a little bit higher for the energy that customers are receiving in South Carolina versus North Carolina, because there would be more natural gas in that South Carolina portfolio. And so that's kind of what I'm talking about. And I think about it, I'll use the example of joint ownership. So, for example, our Catawba nuclear plant, we have joint owners. For their portion of the plant, they pay 100% of the cost of their joint ownership share of the plant. However, for that share of the plant, the capacity and energy that's produced goes 100% to those joint owners. And it's removed from their load when calculating the allocation factors for the rest of the system costs. So this would be very similar. We have some experience doing it. I think it could be fair and equitable to both states. And we're serving the needs of both states. The lights are staying on. We're making sure that we are providing power. It's just a slightly different resource mix that's assigned to South Carolina than what it would be assigned to North Carolina. And I will say, I talk about this, achieving this through removing load from system allocation factors, or this adjustment to allocation factors. You could also take a marginal cost approach that would be more similar to what we do with the joint dispatch agreement, where you look at what's the marginal cost of energy whenever that offshore wind facility is producing power, and do a transfer at that marginal cost of energy between the states. So there's multiple ways to look at it, but it's done through accounting and allocation adjustments. We are serving the needs, the load of both states, and making sure that the lights stay on. But it can accommodate a slightly different resource mix between the states if we can't get to a place of alignment.
And I would just end with that, we do think that P3 fall base meets the requirements of both states. And when I think about our coal retirements, when I think about reducing carbon, when I think about adding renewables, all of those activities are taking place for all of the utilities in South Carolina. We're the only ones that have 951 in the mix, but every single utility in South Carolina is undergoing this same kind of discussion. We're actually operating coal longer than some of the other South Carolina utilities, and so stretching out that resource, which is an ability that we have thanks to the dual state system. So to me, it comes back to are we on the right path? Do we get to the right path through a different exit ramp? And so that's how I continue to think about it, sort of looking around at what else is going on in the state.
Well, and I know you're trying to be on the right path, but we got two different, the legislative requirements, two different states, two different requirements. You got things like that may work in North Carolina, not work here. I just, scratching my head, why is it not feasible to have a separate IRP plan that addresses the system in South Carolina and doesn't take into effect or doesn't take into account North Carolina laws and regulations? Why you're talking about combining the two, Ms. Bateman. Why not combine them state by state rather than the way you talk? It has me scratch my head a little bit. I just, I don't know how you do it. I don't know how either one of you do the job you do, and I commend you for it. But I just don't see why or how, when we have two different sets of laws, that we don't have two different IRPs. Yeah. That you're trying to connect something that's really hard. It's not easy to do.
It is very difficult, and I think one of the difficulties is, just sort of that range of options. Like, how would we even go about doing that? There would be so many different ways to do that if it could be done. But what resources in North Carolina would we assume are not serving South Carolina? What resources in South Carolina that are, that have been paid for a lot by North Carolina customers? What resources would we assume would not be serving North Carolina? Or is there a different way to look at, is there a way to preserve what we have and take a different view on incremental resources? Or what are your geographic assumptions, not yours, but the geographic assumptions in terms of in terms of South Carolina. It's almost it would be easier if we had a law that said you need to look at this, and we had a law over here that said you don't look at that. But we don't have that. We don't have two things that are in opposite. And so that's where we get back to the balancing factors. You know, anything that reduces commodity price risk in our world is going to be something that reduces carbon. And so those are the kind of snapshots and the difficulty. What interstate transmission lines are we going to assume doesn't serve South Carolina or doesn't serve North Carolina when they're, you know, literally connecting the power source to customers who are taking it? That's the difficulty in that example.
And I would just add too that I think, and we've said this before, but we think there are significant benefits to the dual state system. So you ask, why do we not just separate, you know, do North Carolina, and South Carolina? Well, we think that would be giving up some significant benefits. And we've talked about, you know, through the merger that we will gain even more benefits by combining in a larger system. And I think there was a witness earlier in the proceeding that was talking about the larger the footprint, the more efficiencies, the more economies of scale. And so we think there are significant benefits. And when I think about the merger, I mean, Witness Snyder testified to this, that you can site your resources more efficiently, you can build them more efficiently, and you can operate them more efficiently. And we talked about the JDA, over $1 billion of savings since the approval in 2012, so over a 12-year period. When we look at the merger that we're proposing, that creates even more efficiencies, goes above and beyond the JDA. We project our preliminary analysis shows that's over $1 billion in addition to what we're achieving through the JDA over a 12-year period after the merger target closing date. So we think there's significant savings to this larger footprint. And you think about separating the states, you're going the opposite direction. So you're creating a smaller service territory. You're giving up those efficiencies and those economies of scale. You're right, it's a lot less complicated, but is it worth giving up those customer benefits and those savings? And as I sit here today, I think there is still a possibility for alignment. And I do want to talk a little bit about what HB 951 says, because I think maybe there's some confusion about that. But I think there's a possibility for alignment, and if not, I think there's a possibility to accommodate differences but still maintain the dual state system. The kind of third option of completely separating the states, I think the downside of that is losing those efficiencies. So I would see that as kind of the last in the preferences, or the last of the options. But I want to talk a little bit about HB 951 because I think it's been flashed up on the Elmo of the 70% reduction by 2030 and carbon neutrality by 2050. But I want to talk about what it says, because it says that the Utility Commission shall take all reasonable steps to achieve these targets, but it also says that the Commission retains discretion to determine optimal timing and generation resource mix to achieve the least cost path to compliance. And so the Commission retains discretion on how quickly we move to achieve carbon reductions. And so it's reasonable steps to achieve carbon reduction, but the Commission retains discretion on the timing. It also says that the Commission needs to ensure generation and resource changes maintain or improve upon the adequacy and reliability of the existing grid. So to me, that sounds very much like the balancing factors that this Commission needs to consider, looking at adequacy, resource adequacy, and reliability. It says that the Commission in North Carolina needs to comply with current law and practice with respect to the least cost planning for generation. So again, least cost planning sounds very similar to balancing factors that this Commission needs to consider with regard to least cost planning. So I did want to say it's not like a hard and fast rule. And we've talked in terms of dates, and we've talked about we've used the analogy of porridge. Is the porridge too hot, too cold, or just right? I will say I did participate in the proceeding in North Carolina, and there we recommended the same P3 fall base in that proceeding. There were some interveners in that proceeding that thought we should be more aggressive in pursuing carbon reductions. There were other interveners that thought we should move more slowly in pursuing those reductions. And they argued that we could move more slowly and still be compliant with North Carolina law. And so I want to point that out of it's not, there's a lot more discretion and subjectivity than maybe has been presented so far in this proceeding. But they are different statutory requirements. We think that they lead to the same resource plan, like Ms. Smith has testified. If the commissions disagree and we get different direction from the two commissions, we think it's possible to develop that framework that would allow us to maintain the dual state system and those savings for customers, but accommodate differences in resource mix. And then that third option is completely separating the states. You still have issues with you're going to jointly own the existing resources. You probably have some, so there was one example. I know there's a question about, is there an example? So Entergy.
I think that's my point is that you really can't separate them.
Yeah.
So how can you say, well, one state's going to get the benefits and the cost of any sort of resource? I mean, the lines are running all over the place. One thing that you brought up, I thought about with your rebuttal testimony is combining the companies. Does that mean there's a lot of duplication in each company, or they're going to be able to get rid of some people, or how does that go?
So actually, we have done, since the time of the merger of the holding companies, we've done a lot of work to align our processes and our systems and our reporting. And so like my team has aligned and consolidated the formats of all of our reporting, the tools that we use for what we do. So there's been a lot of work in getting those efficiencies already. So there's not much there. Where we get the savings, though, is where you can cite the generation more, because right now both utilities have to build to serve their capacity needs separately. And so if you don't have that separate requirement, you have more options about where geographically to locate new resources.
That'll save money for everybody, won't it?
Yeah.
Okay.
Yeah.
Well, thank you. I'm going to turn it over to Commissioner Cass, and thank you both. Oh, Fairview Road, that's Fountain Inn, right?
It's more Simpsonville, but close to Fountain Inn.
My sister lives on Fairview Road.
It's got a great Target.
It's getting very late, so I want you to answer fully, but please try to be succinct. I'm ready to go too. So I wrote down some things that I want to make sure I understood and some were questions. And this was, I think, I can't remember if you guys started in the morning or after lunch. I don't remember. But in earlier discussions about the portfolios, what I think I heard from you and Ms. Bateman, the inclusion of wind, SMRs, hydrogen, and other stuff I've probably forgotten, included in P1, P2, and P3 fall base. It was to reduce the risk and increased amounts of gas plants, such as those called for in portfolio P0, I think. Have I understood that part correctly?
Yes.
So, does that mean, or are you saying that there's less risk in the viability and timing of those generation and fuel sources than additions of gas plants?
Yes. That's what Mr. Donishad testified to. He said that the resources. I mean, the transcript, of course, will say what it says, but I heard him and I understood his testimony to be that there is more gas than we can build in P0, and that would put us at a much heavier weighting of natural gas in our total energy mix.
I think I do remember him saying that, but I wanted to make sure I understood what you guys thought, because, you know, you said this also. So that said, that the risk of gas, or whether it, and I don't know. I don't know. But I want to make sure I understand, and there's no misunderstanding that Duke Energy, or you on behalf of Duke, and I guess others, are saying that the P3 fall base, those sources down the road, wind has really been trashed since I've been listening. I don't have a thing against wind, so, or any of them for that matter. But saying that, again, the viability and I guess ability to construct them economically in a timely way, and there's less risk in that occurring than building gas plants.
As of today, as of the time this plan is being reviewed, that is our testimony, but it's also a part of the entire balancing factors. We don't get to diversity of generation supply without diversity of generation supply.
I understand that.
And I just maybe want to clarify, maybe I'm not understanding it correctly, that, I mean, we are proposing to add gas plants in P3 fall base.
I understand that too.
Yeah, I think it was just the volume that were required in the P0 portfolio that caused concern.
Okay. Well, that apparently I've understood everything correctly. Okay. So, relative to choosing resources or plans, or us saying we don't want gas, I can't speak for anyone else up here. I don't feel comfortable at all. I think it's my role to tell the company which resources to select or not select. You know, how to do your job. I do still have concern and interest in the front-loaded cost of things that may be premature. I don't know. Duke says it's not. You say it's not. And I have, you know, I'm not going to argue with you about it, because I don't know. There have been reports, news articles, that, you know, cause, I think, concern or pause. But that's the company's testimony, and that's what you're saying.
Yeah, I think we're saying if we want to pursue the long lead time resources in the time frame that we have them in the P3 fall base, that there are certain activities that we would need to pursue in the near term in order to keep that option open.
I've heard that. And I guess my concern still is, and I'll have to reconcile this, is these long-range things or longer-range things, you know, front-load the cost, pretty significant cost, as I recall, that would be paid up front. And if they don't work out, or if it proves not to be the case, okay, well, it's not the case, but that money's gone. The customers in South Carolina paid for it, or their allocated portion.
If it's determined in a future cost recovery proceeding that we acted reasonably and prudently, and those costs were reasonably and prudently incurred, then yes.
So I've understood that part right.
Yes.
Okay.
I also wonder how that Siting Act case goes, right? How does that Siting Act case go, where we're describing the comparison of other generation options, and we're not comparing it to things like nuclear or our other options?
Because I had a question on that. one, this wouldn't be in the Siding Act, if I understand it correctly, because this is front-loaded cost and this is way down the road. So y'all gonna come to us in a year and say, you know what? We want you to decide if wind, is reasonable or meets Siding Act or SMR. I don't anticipate that, but is that what you're telling me?
I think that you're anticipating exactly right, that we would come forth in our next comprehensive IRP and ask if the resources that we have in that IRP, which may be the same or different, are the most reasonable and prudent plan at that time for us to pursue.
That's two different things to me, or I'm not understanding. The IRP is the IRP, and it's a plan that the company thinks that this is the way we should go. Not me, the company. This is the way you think we should go. The Siding Act is when, as I understand the Siding Act, my reading of it, when you've drilled down and getting down in the weeds, and now we're looking at designs, we're looking at systems, we're looking at a facility, and we're going to compare that facility to others. And, you know, not trying to mix everything together, but we're talking about, you know, sole source versus all source and this kind of thing. And I think I even heard one of you say this, and I may have misunderstood that, but all source could make sense even in the Siding Act if you're saying, I think someone said, well, if you're looking at just solar, if you're looking at just gas, you know, we wouldn't be looking at nuclear. Well, maybe not, but how hard could it be in a Siding Act to say, you know, we considered those things and this is why we're not bringing that to you. To me, all source always makes sense, but I could be missing something.
You said a lot, Commissioner, if I could maybe take a stab at breaking it down.
Yes, please do.
So you said a moment ago that, if I understood you correctly, that the companies were asking you to make a determination about resources. The General Assembly has said this commission is the one that decides what's the most reasonable and prudent plan at the time it's reviewed. So we are coming to the commission with what we think the most reasonable and prudent plan is, but y'all do make that call. I mean, y'all make the call at what the most reasonable and prudent plan is, and that does include resources. And I just want to make sure that we're...
I fully understand that. Don't get me wrong.
Okay.
But I'm saying, and I want to make sure that I'm correct, that the company is the one bringing these resources, and you say these are right, these are the way to go, and we're not selecting those resources for you. You're selecting them. You just say, this is what we think is reasonable. We want to head this way.
Yes, of the options that are available in the IRP docket, what's the most reasonable and prudent plan? Yes.
Okay, we're on the same wavelength there.
And then you asked some other questions about
the Siding Act.
About Siding Act. I think it's going to depend upon what the resources are that are being cited and the facts and circumstances surrounding that. So, I mean, the last all-source RFP that I am aware of in South Carolina took 4 years and is still going on. And I believe that's the Urquhart Dominion docket. And so we just don't have that kind of time, number one. Number two, it's not, when the company does RFPs, because I didn't really understand this, but when the company does RFPs, it's a lot of work for a company to respond to an RFP. There is and generally, a lot of times they're binding. So, I mean, there is an entire process that's more than price discovery. Can we do price discovery in a Siding Act? Yeah, there's a lot of ways to do that. But doing RFPs is a different thing, especially when we're looking at third-party providers where the company is not looking to outsource its obligation to serve. We were sitting here in this room not too long ago after Winter Storm Elliott when 1,000 megawatts didn't show up that we had contracted for. We're not looking to do that, but we do understand that we have a duty to compare generation options in a way that makes sense for the resource being compared in Siting Act cases with more information than the generic assumptions that are included in an IRP.
I think I understand how that works. But relative to whether it's all source or an RFP, and it's going to take 4 years, and as you guys got the experience with that, I don't know what it takes for you guys to do it. But when it talks about in the Siting Act, you know, comparing to other generation sources or other generation, what I think I'm hearing is that you're saying if it's gas, it means other gas, or if it's this generation, it means that generation. And what I'm suggesting or asking is, I'm not sure I understand how it takes a long time period to eliminate. It showed where we've compared the option of putting SMR, just throw something out there, or something else here, or gas here, and the gas is the most possible, probable, because, you know, we compared it to these other things in however you do that, whatever the review was. I mean, maybe I don't understand it, but I don't understand the extensive time frame for that. But if that is the case, I'm assuming you don't determine you need generation a year from now, you determined it a few years back.
Well, it got a lot more urgent when we got the economic development forecast.
I understand.
So, but you know, you were talking about nuclear, and we're a long way from this. This is filing for a certificate for a nuclear plant is not in the near-term action plan. But there's only so many things that are alternatives to nuclear. You know, when I think about CCs and that kind of thing. So all source doesn't make sense when you're looking at something like that. And
I'm not, well, okay, if that's what you think, but all I'm suggesting, or I'm asking, I guess, is you just said that if you're comparing it with whatever you compared it to, that, you know, gas wouldn't make sense with nuclear. Maybe not. I suspect that's correct, but I would think if you're doing a comparison, it probably wouldn't take but about 2 or 3 sentences to explain why that's the case, rather than, you know, perhaps not looking at anything else. That's all. I'm just asking that really hypothetically, because when I read the Siting Act, I read that and I just wonder those things. Does that make sense?
it absolutely does, and I think that's a burden that we have in Siting Act cases to make sure that we satisfy that comparison of other generation options question when we make our filing.
So just to kind of wrap this up, at least for me, you know, talking about the other technologies, the front-loaded cost, that there is some concern. And the SMRs, I think I heard, I don't remember who it was. You may. Had mentioned something about citing one of the SMRs maybe at the old Gaffney facility. Which, and I'm assuming, you know, you mentioned the IRA and the tax breaks for pursuing such. Has there been any consideration to reconstituting the abandoned Gaffney facility?
Well, we didn't really break ground on that, is my understanding. We have a license, but we, so, I mean, and customers still have the benefit of that license if we find ourselves in a position to move forward. Where we're moving forward on SMRs is because we have the unique opportunity at a retired coal plant site because we get more federal dollars there. And so that's a direct benefit to customers. I've never heard anyone at Duke Energy say that that the Gaffney site is off the table. We've maintained that license. There are certain South Carolina permits associated with that license. We've very much intentionally kept that license alive so that we do have that option for the future. But in terms of the next step for nuclear, the Belews Creek site just has the most benefit for customers if, from Mr. Capps' testimony and from really everyone that I've talked to in terms of next steps.
I remember that. Finally, relative to preferred plan, I think Commissioner Belser asked about that too. And I was thinking back to, I think the first IRP that we set in, seemed like forever, 2020, whatever it was. And I think it was Mr. Snyder that was arguing that, I think he was saying most appropriate plan or base plan or whatever. Would it make everybody happy if that's what it was again and there was just, whatever's the most appropriate plan, whatever Duke thinks the most appropriate plan? And, it might be this portfolio, but, there's all these other ones too. The most appropriate plan was the base plan, least cost base plan. I remember that.
I remember that too, and I also remember thinking real hard about the statement in the IRP statute that calls upon the most reasonable and prudent plan to be approved. So I feel like we landed in the right spot with the commission's direction that we got in the last 2020 IRP.
Thank you. No more questions.
We have more commissioner questions, which I think will be better served in the morning when everybody's fresh. Tomorrow morning, we have to start a fuel case at 10 o'clock. We're going to open it, and it's not going to be taking a bunch of testimony. So we will be able to come back into this case, I think, at 10:30, or roughly about that time, if everybody could be ready to go back into this at 10:30 in the morning.
Yes, sir.
Does that suit? Let me remind you, you're still under oath. Do not discuss your testimony with these guys over here or anybody else, and we will see you in the morning.
Thank you.
Thank you.
Chair Powers,
Yes.
just for clarification, we're not starting at 9:30 tomorrow.
We're not.
Fine with me. Thank you.
Have a good evening.
Thank you.
Thank you.